Well, a very good morning to you, and we are glad that you have managed to join us this morning for this plenary sitting of the Senate on this Wednesday, 13th of March, the year 2024. And this is a live broadcast that is brought to you by the Parliamentary Broadcasting Unit in partnership with the Kenya Broadcasting Corporation. Now, this is a Senate plenary sitting, and you will notice that today's sitting is starting at 9 in the morning. On normal occasions, the plenary sitting or the Senate proceedings in the morning begin at 9:30, but today's plenary sitting is for the hearing and determination on the proposed removal from office by impeachment of Honorable Dr. Robert Monda, the Deputy Governor of Kisii County. The question from the Speaker, of course, to welcome the members and as well as to welcome the two parties from the Kisii County Deputy Governor's side as well as the Kisii County Assembly's side, and of course acknowledge their presence. And then the Senate will proceed into a closed session. This is a pre-hearing meeting for the senators. They will be within the Senate chambers, but the two sides, that is the county assemblies, Kisii County Assembly Party and the Deputy Governor's side, will not be within the Senate chambers at this time when the senators proceed on a closed session that will take place from 9:20 to around 11. And at this point, the Speaker, of course, will make his communication to the senators. And in this communication, it will be with regards to the do's and don'ts for the members of the Senate with regards to the impeachment process. And of course, the members of the Senate will be furnished with the document, and they will also be able to go through the document, understand the contents of the documents. Remember, the County Assembly has given out 2 volumes of documentation, in this case, their evidence, and the side of the Deputy Governor has furnished the Senate with 1 volume of documentation with regards to evidence. So these are documents that will be given to the senators for them to be able to go through, understand the details and the contents of this particular case or impeachment that is facing the Deputy Governor of Kisii County. And of course, later the House will reconvene and be open for the public, as well as both parties will now come back into the chambers for the hearing process to begin. If you are just joining us, this is a live proceeding of the Senate plenary sitting. This day, the Senate will be sitting in plenary to consider or to hear and determine the removal from office or the proposed removal from office by impeachment of Honorable Dr. Robert Monda, the Deputy Governor of Kisii County. And this, you will realize that the impeachment hearing is done by way of plenary. Remember last week when the Senate considered this particular issue that was brought forth by the County Assembly of Kisii, the Senate did not agree on a committee way that was to be formed by an 11-member, or rather by 11 members of the senators, but it did not sail through, thereby forcing the senators to agree to hear and determine this case by way of plenary. So that is why this particular hearing and determination over the proposed removal from office of Dr. Monda will be done by way of plenary. Otherwise, a Senate normally has 2 ways of going by this, either by committee or by plenary. And since the attempt to set up an 11-member committee to hear this impeachment did not sail through on the floor of the House last week, the House will be hearing and determining this case by way of plenary. The deputy governor is facing 4 charges. This is after the County Assembly of Kisii 2 weeks ago voted to have the deputy governor removed from office. And by law, this case or this impeachment was moved to the Senate to make that determination. Remember, this falls within the mandate of the Senate, which oversees the functions of the county government. So the 4 charges the deputy governor is facing: gross violation of the Constitution, abuse of office, gross misconduct, crimes under national law. These are the charges that the senators will be hearing and will determine later on. The Speaker of the Senate, as you can see, is walking into the chambers. This is Honorable Amason Jeffakingi. Allow me to hand you over to this live broadcast brought to you by PBU in partnership with KBC. Good morning.
Tuombe. Ewe Mwenyezi Mungu, tukusihi ututazame kwa neema nyingi na baraka sisi watumishi wako ambao umeridhika kutuita kwa nyadhifa za uongozi katika jamhuri yetu. Tukuomba utuajalie tuyatende na kufikiria mambo yote yatakayofikishwa mbele yetu kwa njia ya haki na uaminifu, ili kustawisha amani, ufanisi na heri ya nchi yetu na wale ambao haja zao umezikabidhi mikononi mwetu. Amen. Clerk, do we have quorum? Sergeant at Arms, can ring the quorum bell for 10 minutes.
The Speaker has directed that quorum bell be rung for 10 minutes. This is, of course, a pursuant to the House Standing Order. Remember, this is a plenary sitting, and at the commencement of the House business, members that are needed to be present for the House to have achieved its quorum is 15 members. But at the commencement of the House, if there is not that a required number present in the chambers, then the Speaker will order that a quorum bell be rung for 10 minutes. Of course, this is to let members who may be within the precincts of Parliament but yet to get to the chambers to be able to make their way to the chambers. Back to the business of the day is that the Senate this morning is sitting to hear and determine the proposed removal from office by impeachment of Honorable Dr. Robert Monda. This is the Deputy Governor of Kisii County, and this follows the vote by the Kisii County Assembly 2 weeks ago to have the governor be removed from office, of course, accusing him of 4 charges. This include gross violation of the Constitution, abuse of office, gross misconduct, and crimes under national law. The Senate last week decided or voted to have this impeachment process be done by way of plenary after attempts to establish the 11-member committee that would also have looked into this matter failed, and the members decided that this matter be looked at by way of plenary. That is what will be taking place from this morning. The sitting is beginning at 9 a.m. But what we know is that we will be receiving a communication from the Speaker at from 9 to 9:20. This is according to the order of business for the Senate. This communication, of course, remember there are two parties involved in this. The Senate being the determinant of this particular case. So the two parties include the County Assembly as well as the Deputy Governor's side. So in this sitting, we will have the senators inside the chambers as well as the County Assembly side and the Deputy Governor's side, and the Speaker will make a communication. This is, of course, to welcome the parties or those in the chambers, and of course acknowledge their presence and indicate that this sitting will be done in a plenary way. And of course later, after that particular communication, the senators will proceed on a closed session. This is a pre-hearing meeting for the senators in a closed session from 9:20 to around 11 a.m. where the senators will be furnished by the documents or the documentation that has been brought forth by both parties to the Senate with regards to the case before the Senate. This is a quorum bell that is underway. 15 members need to be inside the chambers for the House to commence its business, and this is pursuant to the House Standing Order, much as the chair is taken. But if the House does not have the required number of members inside, then the House cannot commence its businesses because the quorum has not been achieved, and the House has to abide by the standing order. So the bell will be on, and once the quorum is achieved, then the sergeant at arms will alert the clerk, and the Speaker will call the House to order for the proceedings to continue. Remember, once the County Assembly forwarded the letters for the proposed removal from office of the Kisii Deputy Governor to the Senate, both parties, that is the Speaker of the County Assembly of Kisii and the Deputy County Governor of Kisii, were on 8th of March 2024 served by the Senate with invitations to appear before the Senate. That is today, the 13th of March, the year 2024. And these parties were required to file their documentation with the office of the clerk of the Senate by 5 p.m. Monday. This is the Monday of 11th of March 2024. And in this case, the parties were meant to indicate the mode of appearance before the Senate, whether they will be in person or by advocate, or in person and by advocate. So in this case, we will be seeing the parties, that is the County Assembly. We will be getting to know who their side of legal team is, who their witnesses are, and in the documentation, if they have audio or if they have videos or they have sworn affidavits, among other documentation that they will have deemed fit to present before the Senate to support their case. The side of the Deputy Governor also will be able to know, we will be able to know who their legal team is just in a few minutes, and their witnesses, if they have any videos or any audio that they would like to present before the Senate to counter these accusations that are facing the Deputy Governor of Kisii County. This morning is sitting to hear and determine the proposed removal from office by impeachment of Honorable Dr. Robert Monda. This is the Deputy Governor of Kisii County, and this follows the vote by the Kisii County Assembly 2 weeks ago to have the governor be removed from office, of course, accusing him of 4 charges. This include gross violation of the Constitution, abuse of office, gross misconduct, crime and crimes under national law. The Senate last week decided or voted to have this impeachment process be done by way of plenary after attempts to establish the 11-member committee that would also have looked into this matter failed, and the members decided that this matter be looked at by way of plenary. That is what will be taking place from this morning. The sitting is beginning at 9 a.m. But what we know is that we will be receiving a communication from the Speaker at from 9 to 9:20. This is according to the order of business for the Senate. This communication, of course, remember there are 2 parties involved in this. The Senate being the determinant of this particular case. So the 2 parties include the County Assembly as well as the Deputy Governor's side. So in this sitting, we will have the senators inside the chambers as well as the County Assembly side and the Deputy Governor's side, and the Speaker will make a communication. This is, of course, to welcome the parties or those in the chambers, and of course acknowledge their presence and indicate that this sitting will be done in a plenary way. And of course later, after that particular communication, the senators will proceed on a closed session. This is a pre-hearing meeting for the senators in a closed session from 9:20 to around 11 a.m. where the senators will be furnished by the documents or the documentation that has been brought forth by both parties to the Senate with regards to the case before the Senate. This is a quorum bell that is underway. 15 members need to be inside the chambers for the House to commence its business, and this is pursuant to the House Standing Order, much as the chair is taken. But if the House does not have the required number of members inside, then the House cannot commence its businesses because the quorum has not been achieved, and the House has to abide by the standing order. So the bell will be on, and once the quorum is achieved, then the sergeant at arms will alert the clerk, and the Speaker will call the House to order for the proceedings to continue. Remember, once the County Assembly forwarded the letters for the proposed removal from office of the Kisii Deputy Governor to the Senate, both parties, that is the Speaker of the County Assembly of Kisii and the Deputy County Governor of Kisii, were on 8th of March 2024 served by the Senate with invitations to appear before the Senate. That is today, the 13th of March, the year 2024. And these parties were required to file their documentation with the office of the clerk of the Senate by 5 p.m. Monday. This is the Monday of 11th of March 2024. And in this case, the parties were meant to indicate the mode of appearance before the Senate, whether they will be in person or by advocate, or in person and by advocate. So in this case, we will be seeing the parties, that is the county assembly. We will be getting to know who their side of legal team is, who their witnesses are, and in the documentation, if they have audio or if they have videos or they have sworn affidavits, among other documentation that they will have deemed fit to present before the Senate to support their case. The side of the deputy governor also will be able to know, we will be able to know who their legal team is just in a few minutes, and their witnesses, if they have any videos or any audio that they would like to present before the Senate to counter these accusations that are facing the deputy governor of Kisii County. The required documentation that both parties were required to furnish the office of the clerk of the Senate also include, for the county assembly, the designation of not more than 3 members of the county assembly who would attend and represent the assembly in the proceedings before the Senate. Also, the names and addresses of the persons to be called as witnesses, if any, that is for both parties, and witness statements containing a summary of the evidence to be presented by witnesses before the House, and any other evidence that will be relied on as the hearing and the determination of this particular impeachment progresses. The submissions by the County Assembly of Kisii to the Senate is that the County Assembly would appear before the Senate in person and by advocate. So in this case, later in the proceedings, once the Senate is done with its closed session, the County Assembly will be invited to introduce the team, the legal team that will be representing them. Remember, when it wrote to the Senate, it indicated that it would appear before the Senate in person and by advocate. So in this case, they will be required to introduce their legal team as well, and also introduce their witnesses, if any, before the Senate. The County Assembly team of advocates that will be representing it include Mr. The Speaker has directed that quorum bell be rung for 10 minutes. This is, of course, a pursuant to the House Standing Order. Remember, this is a plenary sitting, and at the commencement of the House business, members that are needed to be present for the House to have achieved its impeachment of Honorable Dr. Robert Monda. This is the Deputy Governor of Kisii County, and this follows the vote by the Kisii County Assembly 2 weeks ago to have the governor be removed from office, of course, accusing him of 4 charges. This include gross violation of the Constitution, abuse of office, gross misconduct, crime and crimes under national law. The Senate last week decided or voted to have this impeachment process be done by way of plenary after attempts to establish the 11-member committee that would also have looked into this matter failed, and the members decided that this matter be looked at by way of plenary. That is what will be taking place from this morning. The sitting is beginning at 9 a.m. But what we know is that we will be receiving a communication from the Speaker at from 9 to 9:20. This is according to the order of business for the Senate. This communication, of course, remember there are two parties involved in this. The Senate being the determinant for the Senate. This is a quorum bell that is underway. 15 members need to be inside the chambers for the House to commence its business, and this is pursuant to the House Standing Order, much as the chair is taken. But if the House does not have the required number of members inside, then the House cannot commence its businesses because the quorum has not been achieved, and the House has to abide by the standing order. So the bell will be on, and once the quorum is achieved, then the Sergeant at Arms will alert the clerk, and the Speaker will call the House to order for the proceedings to continue. Remember, once the County Assembly forwarded the letters for the proposed removal from office of the Kisii Deputy Governor to the Senate, both parties, that is the Speaker of the County Assembly of Kisii and the Deputy County Governor of Kisii, were on 8th of March 2024 served by the Senate with invitations to appear before the Senate. That is today, the 13th of March, the year 2024. And these parties were required to file their documentation with the office of the clerk of the Senate by 5 p.m. Monday. This is the Monday of 11th of March 2024. And in this case, the parties were meant to indicate the mode of appearance before the Senate, whether they will be in person or by advocate, or in person and by advocate. So in this case, we will be seeing the parties, that is the County Assembly. We will be getting to know who their side of legal team is, who their witnesses are, and in the documentation, if they have audio or if they have videos or they have sworn affidavits, among other documentation that they will have deemed fit to present before the Senate to support their case. The side of the Deputy Governor also will be able to know, we will be able to know who their legal team is just in a few minutes, and their witnesses, if they have any videos or any audio that they would like to present before the Senate to counter these accusations that is or that are facing the Deputy Governor of Kisii County. The required documentation that both parties were required to furnish the office of the clerk of the Senate also include, for the County Assembly, the designation of not more than 3 members of the County Assembly who would attend and represent the Assembly in the proceedings before the Senate. Also, the names and addresses of the persons to be called as witnesses, if any, that is for both parties, and witness statements containing a summary of the evidence to be presented by witnesses before the House, and any other evidence that will be relied on as the hearing and the determination of this particular impeachment progresses. The submissions by the County Assembly of Kisii to the Senate is that the County Assembly would appear before the Senate in person and by advocate. So in this case, later in the proceedings, once the Senate is done with its closed session, the County Assembly will be invited to introduce the team, the legal team that will be representing them. Remember, when it wrote to the Senate, it indicated that it would appear before the Senate in person and by advocates. So in this case, they will be required to introduce their legal team as well, and also introduce their witnesses, if any, before the Senate. The County Assembly team of advocates that will be representing it include Mr. Ndegwa Njiru, Mr. Elias Mutuma, Mr. Ndegwa Charles Mwangi, Miss Anne Munyoki, and Mr. Victor Wahomemburu. So in this case, later in the proceedings, once the Senate is done with its closed session, the County Assembly will be invited to introduce the team, the legal team that will be representing them. Remember, when it wrote to the Senate, it indicated that it would appear before the Senate in person and by advocates. So in this case, they will be required to introduce their legal team as well, and also introduce their witnesses, if any, before the Senate. The County Assembly team of advocates that will be representing it include Mr. Ndegwa Njiru, Mr. Elias Mutuma, Mr. Ndegwa Charles Mwangi, Miss Anne Munyoki, and Mr. Victor Wahomemburu, who is an IT technical production person. This is the team of advocates, or the legal team that the County Assembly presented the names before the Senate that will be representing them in arguing out their case for the proposed removal from office of the Deputy Governor of Kisii. If you are just joining us, is that the Senate this morning is holding a plenary sitting to hear. All right, allow me to hand you over the speaker, and also introduce their witnesses, if any, before the Senate. The County Assembly team of advocates that will be representing it include Mr. Ndegwa Njiru, Mr. Elias Mutuma, Mr. Ndegwa Charles Mwangi, Miss Anne Munyoki, and Mr. Victor Wahomemburu, who is an IT technical production person. This is the team of advocates, or the legal team that the County Assembly presented the names before the Senate that will be representing them in arguing out their case for the proposed removal from office of the Deputy Governor of Kisii. If you are just joining us, is that the Senate this morning is holding a plenary sitting to hear. All right, allow me to hand you over the speaker.
Senator Chute. Forum now. Clerk, kindly proceed to call the first order.
Order number 1, communication from the chair.
Honorable Senators, you will recall that at a sitting of the Senate held on Thursday, the 7th of March, 2024, I appointed today, Wednesday, 13th of March, and tomorrow, Thursday, 14th of March, 2024, are the days when the Senate will hear the charges for the proposed removal from office by impeachment of Honorable Dr. Robert Monda, the Deputy Governor of Kisii County. At the sitting of the Senate held yesterday, Tuesday, the 12th.
Allow me to welcome you back to this live proceeding of the plenary sitting of the Senate on this 13th day of March, the year 2024. This live broadcast is brought to you by the Parliamentary Broadcasting Unit in partnership with the Kenya Broadcasting Corporation. This is a plenary sitting of the Senate with today's focus being the impeachment motion, the hearing and determination on the proposed removal from office by impeachment of Honorable Dr. Robert Monda. This is the Deputy Governor of Kisii County. This is the day that the Senate had returned to the County Assembly and the Deputy Governor's side to appear before the Senate for the hearing and determination of this impeachment motion. Remember, this hearing and determination will be done by way of plenary, and this is after the House agreed to hear and determine this impeachment motion by way of plenary after the attempts to have the House go the committee way failed and ended up considering the plenary way on this impeachment motion. So if you are just joining us, then this is the impeachment motion on the proposed removal from office by impeachment of Honorable Dr. Robert Monda, the Deputy Governor of Kisii County. In today's plenary sitting, remember earlier on, the Speaker convened the Senate, did a brief communication, and the House proceeded on a closed session. Now the Senate is back from the closed session. Earlier on during the closed session, the senators were furnished with the documents from both parties. This is the County Assembly side as well as the Deputy Governor's side, to be able to go through. They did some little bit of housekeeping on the do's and don'ts. And now the House is back, or the sitting is back. What we expect to be happening now is that there is a preliminary. In this case is that there will be a communication from the Speaker. This communication will be to invite the legal teams, or the councils, if you like, of both parties to introduce themselves. This is their legal team to introduce themselves, as well as introduce the witnesses that they have brought forward to support their case or to counter the accusations. Remember, this is the County Assembly accusing the Deputy Governor of Kisii County of a number of issues. There are 4 charges that the Deputy Governor is facing, and those charges will be heard by plenary way and determined by plenary way. So once the House settles, as you can see, the members are walking in, and of course also the Governor's side will be inside the chambers, as well as the County Assembly side will be inside the chambers. This is the time they will be given to introduce themselves. There are rules. The Senate, the clerk of the Senate will recite the mandate of the Senate, the rules and procedures, and the hearing program. The County Assembly will be given an opportunity to introduce the council that is representing the County Assembly, as well as the Deputy Governor will also be given an opportunity to introduce the council that is representing him. Remember earlier on, I had introduced to you the legal team that will be representing the County Assembly, and the County Assembly had indicated to the Senate that they will be appearing in person, giving out 3 names of County Assembly that will be County Assembly members that will be representing the County Assembly. These include Honorable James Tondari, Honorable Jacob Agaka, and Honorable Henry Moracha. The advocates team that is representing the County Assembly is Mr. Ndegwa Njiru, Mr. Elias Mutuma, Mr. Ndegwa Charles Mwangi, Miss Anne Munyoki, Mr. Victor Wahome Mburu, who is an IT technical production person. They have 5 witnesses that the County Assembly will be calling, but quickly let us take a look at the legal team of the Deputy Governor. before the House begins the hearing is that the county deputy governor will be represented by Masses, Katwa and Kemboi advocates, and this also includes Council Mr. Wilkins Ochoki, Mr. Osoro and Mr. Kelvin Michuki. They have 6 witnesses that the deputy governor will be presenting before the Senate. This include Mr. Joseph Misati, Miss Ann Misati, Honorable Thomas Obare Nyaboro, Honorable Amos Begi Onderi. These are MCAs. Honorable Lilian Anyango Gore, this is a nominated MCA, and Secretary General Kisii Contractors. These are the witnesses on the Deputy Governor's side that they will be presenting before the Senate to counter the accusations that are facing them. Well, the Speaker has taken the chair. We will be keeping a close eye on when he is addressing the House. Allow me now to hand you over to this live broadcast. Good morning.
Senator Veronica, Senator Gloria, kindly take your seats. Honorable Senators, welcome back to this session. Clerk, kindly proceed to call the order.
Order number 1, communication from the chair.
Senator Fernande and the chair devolution. Now, honorable senators, ladies and gentlemen, having dispensed with the pre-hearing meeting of senators, which was a closed-door session, it is now time to commence the proceedings of the proposed removal from office by impeachment of Honorable Dr. Robert Monda, the Deputy Governor of Kisii County. By a letter dated 1st of March 2024, the Speaker of the Kisii County Assembly informed the Speaker of the Senate that at a sitting of the Kisii County Assembly held on Thursday, 29th of February 2024, the County Assembly of Kisii approved a motion for the removal from office by impeachment of Honorable Dr. Robert Monda, the Deputy Governor of Kisii County. The Speaker of the County Assembly of Kisii also forwarded the following documents to the Senate, being the record of proceedings of the County Assembly and the evidence adduced in support of the impeachment motion. 1. Notice of motion for the proposed removal from office of the Deputy Governor dated Monday, the 13th February 2024. 2. List of members in support of the motion. 3. Votes and proceedings of the Assembly sittings held on Tuesday, the 13th of February 2024, afternoon sitting, Wednesday, 21st February 2024, afternoon sitting, and Thursday, 29th February 2024, afternoon sitting. Order paper and supplementary order paper dated the Tuesday, 13th of February 2024, Wednesday, 21st of February 2024, and Thursday, 29th of February 2024. Motion dated Monday, 21st of February 2024. List of members in support of the motion. Hansard for the sitting of the Assembly held on Tuesday, 13th of February 2024 and Wednesday, 21st February 2024. Complaint from Dennis Mokaya Misati to Honorable Wycliffe Siocha Gesongori. Complaint from Dennis Mokaya Misati to Director EACC. Affidavit by Dennis Mokaya Misati. Advert by Guasico. Shortlisting by Guasco. Application for the post of Guasco Commercial Manager, Dennis Mokaya. M-Pesa statement by Dennis Mokaya. Affidavit by Robin Monda Orangi Matundura. M-Pesa statement by Lucy Wahito. Statement by Lucy Wahito. Advertisement of public participation and report. Statement by David Hagai Oyagi. Statement by Gladys Aminga. And statement by Enoch N. Maranga. Pursuant to Section 33(3)(b) of the County Government Act and Standing Order 81A of the Senate Standing Orders, at the sitting of the Senate held on Thursday, 7th of March 2024, the charges against the Deputy Governor of Kisii County, as contained in the motion of impeachment by the County Assembly of Kisii, were read to the assembled Senate. Now, Honorable Senators, ladies and gentlemen, allow me to remind you of the mandate of the Senate in relation to the proposed removal by impeachment of a county governor as provided for under Article 181 of the Constitution, as read together with Section 33 of the County Government Act 2012 and Standing Order 80 of the Senate Standing Orders. In particular, Article 181 of the Constitution provides as follows: a county governor may be removed from office on any of the following grounds: gross violation of the Constitution or any other law, where there are serious reasons for believing that the county governor has committed a crime under national or international law, abuse of office or gross misconduct, or physical or mental incapacity to perform the functions of office of county governor. Parliament shall enact legislation providing for the procedure of removal of a county governor on any of the grounds mentioned in Clause 1. Section 33 of the County Government Act 2012, Senate Standing Orders 80 and the third schedule to the Senate Standing Orders provide for the procedure to be followed in the hearing and determination of the proposed removal from office by impeachment of a governor. Specifically, Section 33(3) and Standing Order 81B of the Senate provide that the Senate may, either by resolution, appoint a special committee comprising 11 of its members to investigate the matter, or investigate the matter in plenary. Further, Standing Order 89 provides that the procedure for removal of a governor shall with necessary modification apply in the case of a deputy governor. Honorable Senators will recall that at a sitting of the Senate held on Thursday, the 7th of March 2024, the motion for the establishment of a special committee was withdrawn pursuant to Standing Order 70. This therefore paved the way for the default position, the hearing of the impeachment charges against the Deputy Governor of Kisii County, to be held by the Senate sitting and plenary. Honorable Senators, ladies and gentlemen, by way of a status update, pursuant to Rules 4A and 6 of the Rules of Procedure, when considering the proposed removal of a governor or a deputy governor in plenary, the Senate invited the deputy governor to appear and be represented before the Senate during the investigation. The Senate further invited the deputy governor, if he so chooses, to appear before the Senate to file an answer to the charges with the office of the clerk of the Senate by 5 p.m. on Monday, 11th of March 2024, setting out 1, the deputy governor's response to the particulars of allegations; 2, the mode of appearance before the Senate, whether in person, by advocate, or in person and by advocate; and 3, the names and addresses of the persons to be called as witnesses, if any, and witness statements containing a summary of the evidence to be presented by such witnesses before the Senate; and lastly, any other evidence to be relied on. Pursuant to Rules 4B and 7 of the Rules of Procedure, when considering the proposed removal of a governor or deputy governor in plenary, the Senate notified the County Assembly of the date of the commencement of the investigation and invited the County Assembly to designate members of the County Assembly who shall appear and be represented before the Senate during the investigation. The County Assembly was further invited, if it so chooses, to appear before the Senate to file with the office of the Clerk of the Senate by 5 p.m. on Monday, 11th of March 2024, setting out documentation of the following: 1, designating the members of the County Assembly, being not more than 3 members, if any, who shall attend and represent the Assembly in the proceedings before the Senate; 2, indicating the mode of appearance before the Senate, whether in person, by advocate, or in person and by advocate; 3, indicating the names and addresses of the persons to be called as witnesses, if any, and witnesses' statements containing a summary of the evidence to be presented by such witnesses before the Senate; and lastly, specifying any other evidence to be relied on. Now, Honorable Senators, ladies and gentlemen, on Monday, the 11th of March 2024, before I proceed, I will allow Honorable Senators to walk in and take the seats. Honorable Senators, ladies and gentlemen, on Monday, the 11th of March 2024, the Office of the Clerk of the Senate received a response to the invitation to appear issued to the Deputy Governor via letter reference number 1/816/24/1, dated the 10th of March 2024. Messrs. Katwa and Kemboy advocates informed the Senate that the firm has been appointed by the Deputy Governor to represent him in the proceedings before the Senate, and that the Deputy Governor would appear in person and by advocates. The letter also indicated the list of counsel representing the Deputy Governor and the list of witnesses for the Deputy Governor. Similarly, on the same day, the Office of the Clerk of the Senate received a response to the invitation to appear issued to the County Assembly of Kisii. Via the letter reference number CIK/3/1/C/CS/003/2024, dated the 8th of March 2024, the Speaker of the County Assembly of Kisii informed the Senate that Messrs. Ndegwa and Ndegwa advocates had been appointed by the County Assembly of Kisii to represent the County Assembly in the hearing, and that the County Assembly would appear and be represented by the advocates. The letter also indicated the list of advocates to represent the County Assembly and a list of witnesses for the County Assembly. Further, via letter reference CIK/3/1/C/CS/002/2024, dated the 8th of March 2024, the Speaker of the County Assembly of Kisii, pursuant to Rule 10 of the third schedule to the Senate Standing Orders, made a request to the Senate to summon Mr. David Hagai Oyagi, the Acting Director, Enforcement and Compliance, County Government of Kisii, to appear before the Senate and produce his appointment letter and confirm if persons who are said to be working the Deputy Governor's home are officials in the county. Pursuant to Rule 8 of the Rules of Procedure, when considering the proposed removal of a governor or deputy governor in plenary, the clerk of the Senate furnished each party with the documentation filed by other party in accordance with Rule 6 and 7 of the Rules of Procedure. Honorable Senators, ladies and gentlemen, the hearing program, which has been appended in today's order paper, details the various activities in hearing and determination of the matter and the time allocated to each activity. It will be crucial, therefore, that all the parties comply with the time allocated. The parties will be notified of the balance of time on each activity through the clerks at the table. In summary, the program states that today, Wednesday, the 12th of March 2024, after we have dispensed with the preliminary matters, the charges against the Deputy Governor shall be read. The Deputy Governor will be given an opportunity to take a plea on the 4 charges. This will be followed by an opening statement in the County Assembly, and thereafter the Deputy Governor. After the conclusion of the opening statements, the presentation of the case of the County Assembly shall commence. After presentation of the case by the County Assembly, Honorable Senators will be given an opportunity to ask questions or seek clarification from the County Assembly. This should take us up to the end of today's sitting. At the sitting scheduled for tomorrow, Thursday, the 14th of March 2024, the Deputy Governor will have an opportunity to present his case before the Senate. Honorable Senators will also be given an opportunity to ask questions or seek clarifications from the Deputy Governor, following which the closing statements by the parties will be made for a period not exceeding 1 hour each. The Senate shall then proceed to debate prior to voting on each of the charges. At this stage, a supplementary order paper will be issued to facilitate this debate. In accordance with Section 33(7) of the County Governments Act and Standing Order 80, subsection 6 of the Senate Standing Orders, the voting shall be by county delegations. The Deputy Governor shall cease to hold office if a majority of the county delegations in the Senate vote to uphold an impeachment charge. If, however, the vote in the Senate fails to result in the removal of the Deputy Governor pursuant to Standing Order 80, subsection 7, the Speaker of the Senate shall notify the Speaker of the Kisii County Assembly accordingly. Honorable Senators, ladies and gentlemen, I now invite Counsel for the County Assembly of Kisii to introduce the legal team of the County Assembly and the members of the Kisii County Assembly representing the County Assembly by stating the full name and the designation of each person. Kindly proceed, the County Assembly.
Thank you, Mr. Speaker, sir. My name is Ndegwa Njiro, advocate for the Kisii County Assembly. I appear alongside my learned friend, Mr. Mutuma. He's present. We are also appearing alongside Mr. Mwangi Ndegwa, present. Equally present is Miss Anne Munyoki. We are equally appearing together with Mr. Gitari, advocate for the County Assembly. Mr. Speaker, sir, on the part of the members of the County Assembly appearing, permit me to put on record the Honorable James Ondari, present. Honorable Jacob Bagaka, present. Honorable Henry Moracha, present. That's our appearance.
Senator Ledama, take your seat. Honorable Senators, ladies and gentlemen, I now similarly invite Counsel for Deputy Governor to introduce the legal team representing the Deputy Governor by stating the full name of each person appearing.
Thank you very much, Honorable Speaker. Honorable Speaker, this is the team, the legal team that appears for the Honorable Deputy Governor. Senior Counsel Katwa Kigen, Counsel Wilkinson Ochoki, Counsel Kevin Michuki, Counsel Wilgrida Majong, and myself, Honorable Speaker, Counsel Silvanus Osoro. Honorable Speaker, the members of the County Assembly appearing include Honorable Amos Onderi, Honorable Boss Mairura, Lillian Gore, and the Honorable Edna Kwamboka, the Honorable Ibrahim Ongubo,
Honorable Osoro, who are those people you're mentioning?
the members of the County Assembly, and who form part of our witnesses, Honorable Speaker.
No. That's not what I asked you to do. I asked you to give the names of the team, the legal team, representing the Deputy Governor.
Okay, Honorable Speaker, I also confirm that the client, His Excellency Deputy Governor Dr. Robert Monda, is also present, Honorable Speaker.
Thank you.
Much obliged.
Very well. Now, on behalf of the Senate, I welcome the team of the County Assembly and the team of the Deputy Governor, members of the public and the media to the Senate and to these proceedings. Finally, I will now invite the clerk to read the charges against the Honorable Dr. Robert Monda, the Deputy Governor of Kisii County.
Order number 2, reading of the charges on the proposed removal from office by impeachment of Honorable Dr. Robert Monda, the Deputy Governor of Kisii County. The Honorable Dr. Robert Onsare Monda, the Deputy Governor, Kisii County, kindly take the stand. Honorable Dr. Robert Onsare Monda, the Deputy Governor of Kisii County, the charges against you as received from the County Assembly of Kisii are as follows, and I quote, Charge number 1, gross violation of the Constitution or any other law. The particulars of the charge are as follows. Whereas Article 179(4) vests Deputy Chief Executive power on the Deputy Governor, and whereas in consideration of the provisions of Article 10 and 73(1) A, 3 and 4 of the Constitution of Kenya 2010, insofar as it connotes the manner in which a state officer is expected to exercise assigned authority, Article 75(1) of the Constitution, as read with sections 8, 9, 10, 11, 24, 32 and 34 of the Leadership and Integrity Act 2012, and sections 9 and 11(1), 2A, 1C of the Public Officer Ethics Act, obligates a state officer to behave in all senses in a manner that is devoid of comprising public or official interest in favor of personal interest. The Deputy Governor's actions of requesting for a bribe, receiving a bribe, is meant to compromise the integrity of the recruitment institution of GWASCO, and the same is driven by nepotism, favoritism, improper and ulterior motives, and for corrupt purposes, in complete disregard of the provisions of Article 73(2)(b) and Article 73(2)(c) of the Constitution. By virtue of the Deputy Governor requesting and receiving a bribe of 800,000 shillings, he is in breach of the provisions of Article 232, which obligates public officers to observe the values and principles of public service that include high standards of professional ethics, fair competition and merit as the basis of appointments and promotions, and Article 73(2)(d) of the Constitution that requires all state officers to be accountable to the public for their decisions and actions. The Deputy Governor, Dr. Robert Onsare Monda, violated Articles 10, 73, 75, and 232 of the Constitution, which bind state officers while discharging their duties in offices inter alia. The Kisii Water and Sanitation Company, GWASCO, advertised for various job vacancies in April 2023, and the said Deputy Governor alerted Dennis Mokaya's father that he could secure his son a job upon paying a bribe of 800,000 shillings only upon his shortlisting and being interviewed for the post. The Deputy Governor used his office to improperly confer a benefit to himself when he solicited a sum of 800,000 shillings from one Dennis Mokaya and his family in the pretext of securing for him a job for the said post of Commercial Manager of GWASCO, an entity of the Kisii County Government. The Deputy Governor received a sum of Kenya shillings 799,000 through the M-Pesa platform as follows. The first tranche on 28th May 2023 of Kenya shillings 249,000, sent in 3 tranches of Kenya shillings 150,000, 49,000 and 50,000 by Dennis Mokaya Mosati on 0725 487 300 to the Deputy Governor's Safaricom line being 0711 860 700. The second one was Kenya shillings 260,000 to the Deputy Governor's Safaricom line being 0711 860 700, and the last tranche in the sum of Kenya shillings 300,000 was delivered to his offices in Kisii Stadium in cash. In an attempt to influence the award of a contract of employment to Dennis Mokaya, the Deputy Governor sent via M-Pesa a sum of Kenya shillings 100,000 to the Managing Director GWASCO in order to influence her to employ the said Dennis Mokaya, which request was not acceded to by the Managing Director GWASCO, and the money returned via M-Pesa to the Deputy Governor. While realizing that the Deputy Chief Executive Authority vests in the Deputy Governor, was there need for the Deputy Governor to grease the palms of the Managing Director of GWASCO to give Dennis Mokaya the said post. Mr. Dennis Mokaya complained to the County Assembly to intervene in its oversight capacity. Mr. Dennis Mokaya thereafter registered a complaint and recorded a statement with EACC and submitted, among other documents, the advertisement from GWASCO on the vacant post to be filled, his letter of application for the job, the invitation letter from Guasco to attend the interview, and his M-Pesa statement for the month of May 2023, detailing the transfer of the Kenya shillings 249,000 to the Deputy Governor. Despite this huge payment made, Mr. Dennis Mokaya and his family never secured the job. On informing the Deputy Governor that he would be forced to make a formal complaint to the Anti-Corruption Commission on the matter, the latter threatened his life and his family. Consequently, it formed the former to go into hiding. Charge number 2, abuse of office. The particulars of this charge are as follows. The actions of the Deputy Governor, the Honorable Dr. Robert Monda, of using his office to solicit for Kenya shillings 800,000, thereby conferring a financial benefit on himself, and subsequently sending Kenya shillings 100,000 to the Guasco Managing Director so as to influence the award of a contract of employment to a preferred interviewee. He has abused the office of the Deputy Governor and is in breach of Articles 73 and 75 of the Constitution of Kenya, Sections 8, 9, 10, 11, 13, 24, 32, and 34 of the Leadership and Integrity Act by breach of public trust, failing to carry out the duties of his office in a professional, transparent, and accountable manner, using his office to unlawfully enrich himself, failing to conduct the duties of his office with impartiality and objectivity in accordance with Articles 10, 27, 73, 2B, and 232, and practicing favoritism and engaging in corrupt or unethical practices and engaging in actions that bully a person. The Deputy Governor is in violation of Section 11(1), 2A, 1C of the Public Officer Ethics Act that provides that a public officer shall not use his office to improperly enrich himself or others, and shall not accept favors from a person who has an interest that may be affected by the carrying out of the public officer's duties, and shall not, for the person's benefit of himself or another, use or allow the use of information that is acquired in connection with the public officer's duties, as well as Section 6(1)(a), C, 2, and 3 of the Bribery Act that provides that a person commits the offense of receiving a bribe if the person requests, agrees to receive, or receives financial or other advantage, intending that a relevant function or activity be performed improperly by that person receiving the bribe, and in anticipation of or as a consequence of a person requesting for or agreeing to receive or accepting a financial or other advantage, an activity is performed improperly by that person or another person. The Deputy Governor unilaterally used the office to intimidate and cow his family into hiding for fearing for their lives in contravention of Section 34 of the Leadership and Integrity Act 2012. In furtherance of abuse of his office, the Deputy Governor has continuously diverted county enforcement officers from their course of duty to work in his farm, a portion of land allocated to him by his father. Since he came into office, there have been at least 5 officers working in the farm, a clear demonstration that the county chief, that the Deputy Executive in Chief is misusing the staff of the county. On the 20th December 2023, the Deputy Executive in Chief employed a contingent of about 20 county officers under the supervision of the sub-county administrator to arrest his brother, one Reuben Monda Orangi, for cutting down trees that his brother, Reuben Monda Orangi, had planted. In exercise of his executive power, the Deputy Executive in Chief ensured his handcuffed brother was bungled in the police vehicle and was incarcerated in Keumbu Police Station for 3 hours without an occurrence booking. At 18:30 hours, the OCS denied the sickly Reuben Monda Orangi, who suffers from high blood pressure and diabetes, and he was immediately transferred to Kisii Central Police Station. At Kisii Police Station, the helpless Reuben Monda Orangi was further denied without a booking on the OB and without the option of bail or bond pending presentation to court. At one point, the sickly Monda Orangi had to be rushed to Kisii Teaching and Referral Hospital for urgent medical intervention. However, on reaching the hospital, Ruben Monda Orangi was never attended to by any doctor, as the OCS Kisii Central Police Station received instructions to immediately take him back to the police station. With his condition now deteriorating, Ruben Monda Orangi was sped back to the police station until 0020 hours, where he was issued with cash bail of Kenya shillings 30. The medical condition of the old man deteriorated to the extent that he was hospitalized at Coptic Hospital for about 3 weeks, and since then he has been injected insulin, a condition that was not there before. Charge number 3, gross misconduct. The particulars of this charge are as follows. The Deputy Governor interfered with the appointment of the vacant position of the commercial manager of Guasco by attempting to bribe the managing director, Ms. Lucy Wahito Washira, with a sum of Kenya shillings 100,000. This was in May 2023. This act contravened Article 75 of the Constitution of Kenya. The Deputy Governor's engagement, connivance, and/or complicit behavior boils down to gross misconduct and gross abuse of office. Charge number 4, crimes under national law. The particulars of this charge are as follows. The actions of the Deputy Governor, the Honorable Dr. Robert Monda, of using his office to solicit for Kenya shillings 800,000, thereby conferring a financial benefit to himself, and subsequently sending Kenya shillings 100,000 to the Guasco managing director so as to influence the award of a contract of employment to a preferred interviewee, he is in violation of Section 61A, C, 2 and 3 of the Bribery Act that provides that a person commits the offense of receiving a bribe if the person requests, agrees to receive, or receives a financial or other advantage, intending that in consequence a relevant function or activity should be performed improperly, whether by that person receiving the bribe or by another person. The Honorable Dr. Robert Onsare Monda, how do you plead to charge number 1? Guilty or not guilty?
Not guilty, Mr. Speaker, sir.
Honorable Dr. Monda, how do you plead to charge number 2? Guilty or not guilty?
Not guilty, Mr. Speaker.
How do you plead to charge number 3? Guilty or not guilty?
Not guilty, Mr. Speaker, sir.
And how do you plead to charge number 4? Guilty or not guilty?
Not guilty, Mr. Speaker, sir.
Thank you. You may take your seat, Deputy Governor. Now, honorable senators, ladies and gentlemen, at this juncture, I will allow the opening statement on behalf of the County Assembly. You have 30 minutes to do that.
Mr. Speaker, sir, this is Ndegwa Njiru. Perhaps before I do my opening remarks or statement with assistance of my fellow counsel, permit me, Mr. Speaker, sir, to draw the attention of the House to the letter dated 8th of March 2024, which letter invoked rule number 10 of the third schedule of the rules governing these proceedings.
Yes, Senator Mazayo, what is the issue?
Thank you, Mr. Speaker. It would be better if the Council would be able to guide by saying which volume he is referring to that we have, so that we are able to see.
So as you make your opening statement, please pinpoint exactly which volume you're referring to and even the page where that document you're mentioning is contained.
I'm well guided, Mr. Speaker, sir. The letter that I'm referring to, Mr. Speaker, sir, is the letter that was sent by the Speaker and the Clerk of the County Assembly of Kisii to the Clerk of the Senate, which letter was seeking to invoke the provisions of Rule 10 insofar as the question of issuance of summons are in issue. And therefore, that
where is that later contained? So
not,
that the honorable senators can follow?
Honorable Speaker, the letter does not form part of the proceedings. It's
Okay,
a letter that you referred to.
the clerk just informed me exactly that, and it's being made available to honorable senators. May the copies be circulated to the honorable senators.
I am most obliged, Mr. Speaker, sir. And as such, Mr. Speaker, sir, permit me to make an application pursuant to Rule 10 of these House proceedings, equally assisted by Article 50 of the Constitution, that this Honorable Court be pleased to issue summons to one Mr. David Hagai Oyagi. Mr. David Hagai Oyagi works with the Kisii County government as a Director of Enforcement and Compliance. The basis of our application, Mr. Speaker, sir, is that while the charges were being read out to His Excellency the Deputy Governor, there was a charge that involved the misuse of the county resources, to wit, 20 enforcement officers were unlawfully deployed to arrest and harass one Mr. Ruben Onari Monda, and subsequently the charges have also indicated that at least 4 county enforcement officers are deployed by the Deputy Governor of Kisii County to conduct and execute odd jobs such as milking cows, cooking for dogs, at the residence of the Deputy Governor. In the application for summons, we requested the Senate to indicate to the said David that he should produce his appointment letter and any other relevant document that speaks to or against the allegations. Mr. Speaker, sir, the summons being sought will assist this Honorable House to meet its mandate under Section 33, which provides that other than just presiding for a hearing of a case such as this one, Section 33 permits this House also to initiate investigations into the allegations so as to determine the propriety or the impropriety of the allegation contained therein. If the summons being sought by the County Assembly are therefore issued, the Deputy Governor will suffer no prejudice whatsoever, as he'll be granted an opportunity to test the veracity of the statements or evidence that shall be adduced before this House by the said David Hagai Oyagi. Mr. Speaker, sir, these are clear tenets dictated by Article 50 of the Constitution, which the Constitution provides that Article 50 is a non-derogable right, a right to a fair hearing. A fair hearing in this case, Mr. Speaker, sir, and the interpretation of the County Assembly of Kisii means that the Senate shall be afforded an opportunity and the facilities available to determine the veracity of that case. Mr. Speaker, sir, the refusal to issue the summons to the said David Hagai will deny this Senate an opportunity to test whether or not the Deputy Governor of Kisii County has been abusing his office by misapplication and misappropriation of the county resources. It's all known to us that human resource is a rare resource that facilitates and wills the movement of the county, the administration of the county. Therefore, the question for determination when determining to grant, to issue the summons or not to grant, is therefore, will the Senate be afforded a proper opportunity to test the veracity of that issue? Finally, Mr. Speaker, sir, in the body of the documents that were sent to us and that were shared and exchanged by the respondents, herein being the Deputy Governor, we are making an application before this court that paragraph 48 all the way to paragraph 49 of the document be expunged for being irrelevant to these proceedings, and that the same do not speak to the question or to the case before the Senate. Mr. Speaker, sir, the offending paragraphs which appears that is the Deputy Governor's...
Yes, just hold on, Council. Senator Mogeni, what is the issue?
Yeah, Mr. Speaker, the Council is doing very well, but for purposes of us being able to follow his submissions easily, we will want him to make reference to the particular volume of the document is making reference to, and if possible, refer us to the page so that we are able to move with him.
Council, I thought I've made that position pretty clear.
Sir, I was just about to make reference. Mr. Speaker, sir, I'm referring to the body of document appearing in blue from the firm of my senior line friend, Mr. Katwa Kigen and Kimboi, marked as DG. That is a response, and again the document is dated the 10th of March 2024. Mr. Speaker, I am referring to...
What is the title of that volume, Council?
It's DG. It belongs to the Deputy Governor. It's indicated in black as DG, to mean, I think, Deputy Governor. At page E8, 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 E into brackets 8.
What is the issue, Senator Fernandi?
Mr. Speaker, I had indicated earlier that I had a clarification that I needed to seek under Constitutional Article 71 and then the impeachment procedure bill, impeachment procedure under the standing orders. So I wanted to get your guidance and maybe a ruling, because one of the lawyers that is representing the Deputy Governor of Kisii
Senator Fernandi
happens to be...
Senator Fernandi will come to that. Let the parties...
Okay, thank you.
Positions. Proceed, Council.
Thank you, Mr. Speaker, sir. I hope the honorable senators are with me. At page 8, paragraph 48, all the way to page 15, paragraph 64. Mr. Speaker, sir, The paragraphs that I have highlighted contains material facts that do not relate to the proceedings before the Senate. Number 2, Mr. Speaker, sir, the paragraphs that I have indicated mentions individuals or makes reference to individuals who are not party to these proceedings. For example, Mr. Speaker, sir, a look at paragraph 53 of the said document appearing at page 9 of the document make references to the governor of Kisii County. Further to that, Mr. Speaker, sir, at paragraph 61, at page 13 of the document, again, the document makes reference to the spouse, that's the first lady, to the governor of Kisii County. Equally, Mr. Speaker, sir, the pages makes reference to matters of budgets, and more so paragraph 56, 57, 58, at page, all the way to page 11. Those are not matters that forms part and parcel of these proceedings. The consequence of this pleading will only embarrass individuals who are not party to these proceedings, and not just embarrass, but deny them an opportunity to appear and be heard by this distinguished house. We all understand that it's strike law that the doctrines of natural justice, granting a party an opportunity to be heard, is one of the principles elucidated under Article 50 of the Constitution. And as such, Mr. Speaker, sir, the aforementioned paragraphs, it's our humble prayer that the same should be expunged from record, as they do not form part and parcel of the allegations contained in the charge now read to the Deputy Governor. As I sum up, Mr. Speaker, sir, and invite my learned friend, Mr. Mutuma, for supplementary submissions, permit me, Mr. Speaker, sir, to lead the House to page 12 of the document and paragraph F, just to indicate the irrelevance of the evidence contained. It makes reference to the members of the Judicial Service Commission. The allegations are that the Judicial Service Commission, that the effect of conducting county affairs, I may read in verbatim, and files at the personal residence is that the governor's wife attends meetings, makes inputs to official county matters, and serves as both protocol officers and deputy governor, inter alia, the Judicial Service Commission. In determining the relevance of these averments contained in the for said paragraphs, we invite the Senate to interrogate the purpose of such kind of averments, the objective of such kind of averments, and whether or not they inform the charge. Finally, Mr. Speaker, sir, permit me to guide the House to page 15 at paragraph 64. Again, it makes references to individuals not before this assembly, make references to video clips and photos that did not form part and parcel of the evidence at the county assembly. Suffice to note that during the proceedings at the county assembly, the deputy governor, beg your pardon, appeared before the county assembly and filed his response dated the 29th of February. These video clips have no relevance to the proceedings, and I'm aware that it may prejudice the senators' determination as to the relevance of these video clips because they have not yet been played. We had the opportunity of reviewing them and analyzing them and made an opinion to which we invite the honorable senators to hold that they have no relevance. It may perhaps be paramount, or it perhaps may be important for those clips to be played for the senators to determine their relevance when determining to expurge the said paragraphs. With your kind permission, Mr. Speaker, sir, permit me to invite Mr. Mutuma for further submissions.
Thank you, Mr. Speaker, sir. For record purposes, my name is Elias Mutuma, part of the legal team representing the County Assembly of Kisii. I want to make additional submissions, Mr. Speaker, sir, in addition to the relevant materials before this House. Mr. Speaker, sir, you will note that the charges as read by the House to the Honorable Deputy Governor contain four charges rather. Very specific charges that have been read, and the Deputy Governor has been able to respond that he's not guilty of the four charges. Mr. Speaker, sir, it is the four charges that were prosecuted by the County Assembly of Kisii. It is the four charges that the Honorable Deputy Governor responded to. It is the four charges that this House has been invited to make a determination on. Those charges, Mr. Speaker, sir, are contained at pages 15 and 21 of the County Assembly's bundle of documents. The same are, if I may read, page 15, page 15 contains the motion. Page 16, we have the first charge, gross violation of the Constitution or any other law. Charge number 2 is contained at pages 18, abuse of office. Charge number 3 is contained at page 20, crimes under national law. And the last one is contained as gross misconduct in the same page. Now, Mr. Speaker, sir, in response to those charges, the Honorable Deputy Speaker, or the Honorable Deputy Governor of Kisii responded through a response that has been filed in this court, in this Senate, and he has introduced a raft of other charges that he has created for himself and made a response to them. Those responses are the following. Mr. Speaker, sir, if you look at the Deputy Governor's response, the one my learned friend has made reference to, as from page 8, the Deputy Governor creates new charges that were not part of the County Assembly's charges. One of those is incompetence, budget absorption, budget variation, use of senior staff, mortgage provision, use of personal home for county functions and files and documents, not working with other leaders, use of an official personnel on county matters, and he proceeds to make a defense on those charges. Those charges have not been read to the Deputy Governor, but this House is being invited to make a determination on those matters. It would be a waste of crucial time for this House to proceed and listen to a defense that contains a response to charges that were not part of the charges by the County Assembly. It is on that basis, Mr. Speaker, sir, that we ask the honorable senators to expunge that part of the response because it has no bearing, it has no relevance to these proceedings. That is all, Mr. Speaker, sir.
The side of the County Assembly, are you done with your opening statement?
Mr. Speaker, sir, we addressed the Honorable House pursuant to Rule 10 on preliminary issues because our opening remarks or statements may not be material until this question is determined because it will inform on how then our opening remarks then will be made and put across.
You see, Council, you could have made your opening remarks, and in so doing, you raise these issues so that the team from the Deputy Governor, representing the Deputy Governor, in their opening statement also will have an opportunity also to respond to your preliminary objections. And thereafter, then the Senate will make a determination on those issues.
I am well guided, Mr. Speaker, sir, but as a practitioner, I think I'm so fixated to the court proceedings, which dictates that preliminary issues ought to be addressed first, so that...
Very well, if that is your position, then have your seat.
But I may be guided, Mr. Speaker, sir.
Then well, I've guided you,
perhaps
but
I can make the opening remarks, if you may allow me, Mr. Speaker, sir.
Please, proceed.
Mr. Speaker, sir, I'll take the first 10 minutes, then I'll share with my colleagues in respect to the opening remarks.
What is the point of order, Senator, for Baringo?
Thank you, Mr. Speaker. I've listened keenly to the councils for the County Assembly. Mr. Speaker, I thought your guidance was clear because the stage you are in, Mr. Speaker, as per the program, is actually opening statement on behalf of the County Assembly. I am worried, Mr. Speaker, that if we allow further, we are likely to lose the track. Mr. Speaker, this is not a case between this assembly, or rather this house, and any of the parties. It is their case. Mr. Speaker, I want to plead that perhaps you reconsider your position because we wanted therefore to, and again, Mr. Speaker, for you to be directed that you make a finding at this point. It is not a speaker, it is the House. So, Mr. Speaker, guide us on that issue because a very sensitive matter. This House is being watched now across the country and the world.
Senator Mogeni.
Yes, Mr. Speaker.
Senator Sifuna, you don't have to beg. I will give you an opportunity.
Yeah, Mr. Speaker, maybe just to assist counsel for the County Assembly. You know, I thought his opening remarks would have given him an opportunity to summarize for us, senators, what the case for the County Assembly is, so that he sets the stage for us to make a following. In terms of the objections that he has, when the time comes for that evidence to be adduced by the Deputy Governor, maybe he could raise his objection. But he should utilize, with tremendous respect to him, the opening remarks to summarize for us, because we just want to know, to have a glimpse of the case that is facing the Deputy Governor. And you have guided him. Maybe we should also advise him that it's good you take the ruling of the Speaker as a guidance for you, so that you follow and you make these proceedings simpler for us to follow.
Yeah, Senator Sifuna.
Mr. Speaker, with the greatest respect to all the senior counsel who have spoken before me, I believe that this is a quasi-judicial proceeding, and the Council for the Assembly is very much in order to require that a ruling be made on the preliminary requests. The only thing I fault them for is being too verbose on a very simple request. A request has been made pursuant to Rule 10 of these proceedings that a witness be summoned by this House. We need to make a decision after hearing, of course, from the team for the Deputy Governor on whether there's going to be any prejudice if this gentleman called David Hagai Oyagi is summoned. That is a matter that has to be dispensed with before we hear opening remarks. Mr. Speaker, the second request is expunging of certain paragraphs that are being claimed not to be relevant. That's all this council needed to say without going into too many stories, because we would want to get into the meat of the argument. But, Honorable Speaker, preliminary matters must be dealt with at the preliminary point so that it will set the tone on what we're going to hear and what we're not going to hear. So I request that the House makes a determination on the request to summon this gentleman, and if it is after hearing the Council for the Deputy Governor, then we move. Then we make a decision on the other question, whether we want to expunge those paragraphs now, or we wait until we see the irrelevance, then we expunge them at that particular point. That is the guidance that I wanted to give the House, Mr. Speaker, and I thank you for the opportunity.
Senator Fernandi.
Mr. Speaker, I agree largely with my colleagues who have spoken before me. We needed to either we allow the councils for the county assembly to make opening remarks, but I thought, Mr. Speaker, as a tradition and precedent, we always dispense of the preliminary objections. And on the issue of expunging the paragraphs that they have requested, the summoning of witnesses, Mr. Speaker, I thought you should have guided them so that we dispense of. But now the question should be, when you invited them to speak for 30 minutes, was it on the aspect of their opening remarks, Mr. Speaker, or was it on the aspect of raising preliminary objections? Because in my thinking, he would have allowed that the preliminary objections are raised, dispensed of, then now it sets down for the engagement. And in the opening remarks, my colleague, Mr. Speaker, they should have given us an overview of their case. With no pun intended, Mr. Speaker, it should have been like a woman's skirt, long enough to cover essentials, short enough to arouse curiosity, Mr. Speaker, so that it gives and sets the tone, Mr. Speaker, of Mr. Speaker, so that it sets the tone. Or I'm not making, I said, Mr. Speaker, no pun intended. Can you be listening carefully, my colleagues? So that is, I was just saying, Mr. Speaker, can you protect me, Mr. Speaker?
Well, I will protect you if you're orderly.
Yes, I'm orderly, Mr. Speaker.
Proceed.
I'm orderly, Mr. Speaker, because I was saying in opening remarks, Mr. Speaker, it should be something that is long enough to cover essentials and something short enough to arouse curiosity. And that is what is all about the opening statement, Mr. Speaker. So my request allow us to raise the PO, dispense of the preliminary objections, then allow them to give them the opening remarks, and I've given them a simple advice, and I hope they will take it. Thank you, Mr. Speaker.
Honorable Senators, allow me to guide the House as follows. If you look at the program, between 11:45 to 12:15, that time was reserved for the opening statement of the County Assembly, and thereafter to be followed by the opening statement on behalf of the Deputy Governor. Now, Honorable Senators, as the County Assembly is making its opening statement, they can, on the same breath, raise the preliminary objections. Thereafter, when the Deputy Governor is making the opening statement, in the same breath, they can respond to the preliminary objections raised by the County Assembly. if you look at the document before you, it contains some preliminary objections by the Deputy Governor. And I want to believe as they're making their statement, they will also canvass those preliminary objections, to which then I will allow the County Assembly to respond. Thereafter, Honorable Senators, you'll have an opportunity to deliberate on those preliminary objections, dispense with the same, to allow then after the lunch break to hear the evidence. Because we cannot assign time to hear only preliminary objections, dispense with them, then come back for opening statements. Let us handle them at the same time. So, County Assembly, your 30 minutes is long gone. However, with this new direction that I've given, the directive that I've given, I will allow you to put what is the case of the County Assembly. You have dealt more on the preliminary objections. Proceed to state your case before we allow the representation from the Deputy Governor to also give us their opening statement.
We must oblige.
That way we'll save on time.
Thank you, Mr. Speaker, sir. Mr. Speaker, sir, our case is very simple. It's a case of a Deputy Governor who decides to use his office for personal gain. Is a Deputy Governor gone rogue. Is a Deputy Governor who has decided not to inspire the youth of this country. In my opening remarks, permit me, Mr. Speaker, sir, to refer to the book of Exodus, chapter 18, verse 21. Moreover, look for able men from all the people, men who fear God, who are trustworthy and hate bribes. Equally, Mr. Speaker, sir, permit me to refer to Surah ya Pili, or the second chapter, verse 188 of the Quran. And they are taking of bribe, to thou were forbidden, for taking it and the devouring of men, substance worthiful bribes. And we have prepared for the disbelief among them and a painful moment. Mr. Speaker, sir, on the 29th, the county government of Kisii, through the Guasco, advertises for a job for the commercial manager. The job is carried on the newspaper. The deputy governor gets to know about it, informs his friend Mr. Joseph Mosati, whom he alleges he has been friends for the last 32 years, that here is an opportunity where your son can take or can be absorbed into the employment, makes arrangements on how to extort, defraud, and benefit with 800,000 shillings, creates a scheme where he meets the managing director of Guasco, informs her in advance that I have a candidate who will be presenting his application before you, convinces her or attempts to convince her that at the appropriate time I will do the necessary. And the necessary hearing being bribing the director of Guasco for purposes of return of a favor in favor of Dennis Mosati. Dennis Mosati is given the responsibility by his father to raise the 800,000 shillings. A young man, a poor man, a jobless man, a family man, a man who is destitute and desperate for a job, does all that is within his means, sells his salon so as to raise the 800,000 shillings, sells all his households, sufurias and everything else, so that he can raise the 800,000 shillings as sought by the deputy governor. Succeeds in that mission, raises the money even from his friends, and And upon the success of the mission of raising the 800,000 shillings, forwards the same. The father is involved in that scheme, the mother is involved in that scheme, but finally the money lands to the deputy governor. Through the M-Pesa, through cash, the county assembly shall give evidence to that extent that yes, money was sent from the M-Pesa of Joseph Mosati, money was sent from the M-Pesa of Dennis Mosati, the complainant, and equally money was sent from the M-Pesa of Ann Musati. And the money all landed to the benefit of the M-Pesa of the deputy governor. Subsequently, on the same day, the deputy governor sends 100,000 shillings to one Lucy Wahito. Upon receipt of this 100,000 shillings, Lucy Wahito, the managing director of Guasco, is perplexed, wonders why the deputy governor has decided to be that generous. Upon placing a call to the deputy governor in search of the reason for the forwarding of the remittance of the said amount, the deputy governor merely makes a statement. You remember what I told you? This is meant for what I had told you when I summoned you in my office. The good Lucy Muhito decides to resend the said amount, refuses to be influenced, refuses to be bribed, refuses to be corrupt. In essence, Lucy Wahito meets the qualification of the qualifications of the persons described by the Bible and by the Quran, refuses to be corruptible. Finally, the deputy governor receives the money, 100,000 shillings, resent back to him, and makes no further follow-ups. In his defense, he says that this was made to you, Lucy, as an error, takes no efforts to refund the same, to reverse, or even to call Lucy for the reversal. The other limb of the case, Mr. Speaker, sir, is where the deputy governor decides to abuse his office. Being the powerful man that he is, and his brother being the miserable old man that he is, decides to have it fixed his way. He mobilizes the county government enforcement officers to go and arrest the poor Monda, the sickly Ruben Monda, the hopeless Ruben Monda. He's burdened into the police vehicle, courtesy and at the behest of the deputy governor. At the county assembly, Hanson bears as witness that yes, he confirmed that he's the one who mobilized the said enforcement officers. And be that as it may, the deputy governor, with all the resources afforded to him, decides even to apply the county resources in applying 4 officers, enforcement officers, uniformed to do odd chores at his farm. Odd as even cooking for his dogs. So the county government the Senate is presented with a case such as this one. Previously, the cases of impeachment, they have been pegged mostly on the question of the violation of the constitution and the mismanagement of county resources. This is a unique case. It's a case where we are not inviting the senators to look at whether or not there is any resource or funds that have been lost. The question of oversight means that the Senate also has to look and interrogate whether the persons in the name of the county deputy governor squares out with chapter 6 of the constitution. Is this a man full of integrity? Is this a man who can be trusted? Is this a man who can be held to account? Is this a man who is transparent? Is this a man who can inspire the youths? Is this a man who can be trusted with the county resources? Evidence will bear us witness when we begin to tender the same, that Dennis is not the only victim. The public participation processes that were conducted on the 26th of February, we have people claiming that yes, the deputy governor is a man who is full of insatiable greed for resources, to the extent that he solicits resources as low as 8,000 shillings so that he can facilitate the governor's bursaries. That is the man that is being trusted to oversee the activities of the county government of Kisii. Evidence will be tendered, honorable senators, at the fullness of time to prove that this is a man who does not deserve the mercy of this house. This is a man who does not deserve any further stay and holding that position of a deputy governor. How can a deputy governor solicit 20,000 shillings so that he can assist poor people, hustlers, to access the bursary? The deputy governor, you are elected by these individuals to serve them, but you end at the end of the day, you end by extorting them, defrauding them. Is not a man worth his salt. This is not a man worth the favor of this house. Permit me to invite Mr. Mutuma for further submissions. Sorry, Mr. Mwangi, Mr. Speaker, sir.
Mr. Speaker, sir, my name is Mwangi. I rise to Mr. Speaker, sir, the Deputy Governor receives money from Dennis Misiati at 8:33 p.m. He receives another bunch of 49,000 at 20:37 p.m. on 28th of May 2023, and within a span of 40 minutes sends 100,000 shillings to the Managing Director of Guasco, Lucy Wahito, at 21:24 p.m. on the 28th of May 2023. He further sends money to 3 other people on the same day, 28th of May 2023, and the last transaction on that day was made at midnight. So he sends 100,000 shillings, and in his defense he raises the issue that this money was sent by an error. Surely from 9:24 p.m. to midnight, when he was sending the last transaction on that day, the Deputy Governor did not realize that he has sent money by an error until he is reminded by one Lucy the following morning. Honorable Speaker, on the issue of arresting his own blood brother, Ruben Monda, the Deputy Governor deploys not only 1, not 2, not 3, but a contingency of 20 county enforcement officers, accompanying police officers, to come and arrest and bundle his own brother into a motor vehicle. Surprisingly, Mr. Speaker, his own brother today, because of the events that the ordeal that he went through on that day, he is now a diabetic man who has since started injecting himself with insulin, a condition that was not there before then. Honorable members, as I cede my 10 minutes to Mr. Mutuma, I invite this honorable house to make a determination on the issue of whether or not the Honorable Deputy Governor should be removed from office by way of impeachment, as we have shown, and we shall strictly indicate to you and bring out through the witnesses that there was a clear and well calculated way by the Deputy Governor, who even confirms that he spoke to one Lucy to seek for favors. And he confirms that also during the county assembly, and the Hansard confirms so. He also confirms that he spoke to Lucy about the issues of the bribe, but Lucy told him that the interview will be done by way of merit. Honorable members, I cede my few minutes to Mr. Mutuma.
Thank you, Mr. Speaker, sir, and the honorable members of the Senate. The case of the Kisii County Assembly is simple. It is a cry by the most vulnerable members of our society who have suffered at the hands of their leaders. It is a case of the most vulnerable members of the society who have been exploited by those in positions, those that they pay through their own taxpayers' money, and that is what these honorable senators are being invited to make a determination on. Honorable Speaker, sir, you will realize from the testimony of Dennis Misati that as a result of this ordeal, after 12 years of trial, getting their second born, the wife was so depressed to the extent that she collapsed and lost the baby. The thought of having sold everything that they had, the thought of losing everything that they were calling a source of livelihood was too much for her to bear. She had to undergo a miscarriage at the hands of the deputy governor. Last year, but one, honorable senators, I had the opportunity of appearing before the Supreme Court where we were on the same side with my learned friend, Mr. Katwa Kigen, and I want to quote him. He told the honorable judges of the Supreme Court that you have a right to be hungry. You have a right to be bitter. When a witness appears before you and concocts facts, when a witness appears before you and twists events and lies to you, looking at you straight in the eyes and tries to twist a very simple issue, then as honorable senators, you have a right to be angry. When you listen to the testimony of the deputy governor, you have that right. Invoke it. Tell him he's lying. Tell him that whatever he's telling you does not make sense. You do not receive money from an innocent person. Send it to the very person that you're being accused of seeking a favor from. You do not make attempts to reverse 48 hours later. The person you're seeking to bribe asks you to reverse, you do not. Then you come before Senate and look them straight in the eye and say, I had sent that money by mistake. You have a right to be angry. Exercise that right. Most obliged, Mr. Speaker, sir.
The County Assembly team, you've concluded your statement?
Yes, Mr. Speaker, sir.
Thank you.
Other than just to mention that the simplicity of this case was witnessed on the 31st of December 2012, when the Deputy Chief Justice, as then she was, Honorable Lady Justice Nancy Baraza, pinched someone's nose. Rebecca was a victim. Just pinching the nose of an individual caused the Deputy Chief Justice of the Republic of Kenya to go home. That is a test. The test is, can a public officer, a state officer, be allowed to behave in such a manner? Does the conduct of the deputy governor answer to the tenets of Article 10? Is he accountable? Is he transparent? Is he a man of integrity? Does he respect his office? Does this conduct bring honor and reputation to the office of the deputy governor? Equally, Mr. Speaker, sir, the case of Nixon in 1974, he faced impeachment only on the count of the Watergate case. What had the President of the Republic of America done, the United States of America done? Sent individuals to go and break into the Democratic National Convention offices at Watergate. Then he made attempts to conceal that evidence. On that basis, a president went home. On the basis of soliciting, receiving 800,000 shillings from poor Kenyans, Mr. Monda must go home. On the basis of using the state resources to harass innocent and hopeless Kenyans, Mr. Monda must go home. On the count of misuse of the county resources, the meager county resources, Mr. Monda must go home. I so invite the senators to keenly look at the case of Nixon and the case of Nancy Baraza. Most obliged.
Thank you. Now I will allow the team of the Deputy Governor to take us through their statement. Now, Council, there's a difference between an opening statement and a final submission. Because what I've just heard from the last bit of the county assembly, those are final submissions. So let's hear your opening statement, not your final submission.
Thank you, Mr. Speaker, sir, and members of the Senate. When we come down to cross-examining the witnesses that have been that will be called by the by the county assembly, and when we call our witnesses, you will be surprised at how far the person they are describing is from what they have described him. You will be surprised at how exaggerated the adjectives they have used are. You will realize that the Deputy Governor is indeed a man of integrity, a Christian, and a man of conscience. I would like to address the 5 counts. I know there is repeated contention that there are 4, but there are 5. The first one is whether or not he took a bribe from one Dennis Misati. The second one is whether he gave a bribe to one Lucy Wahito. The third one is whether he threatened one Dennis Misati. The fourth one is whether he misused the staff of the county assembly. And the fifth one is whether he misused his authority to have his brother arrested. On the first count, members of the Senate, the allegation is basically this, that the Deputy Governor received a sum of, in some paragraphs of their claim, they say he received 799,000 shillings. In others, they say he received 800. And that 800,000 was meant to be a bribe to enable Dennis get a job. Our case will be this, and in the introductory part of the introduction of the said Dennis, he is described as a 37-year-old gentleman. Our case will be this, that the sum of 800,000 was received by the Deputy Governor. However, that amount was a refund of money he had lent to the father of Dennis. We will be calling the father of Dennis to come and confirm that indeed, number one, he received that money from the Deputy Governor in the period around October, November 2022, and on the 28th of May 2023, when he visited Mr. Monda, Mr. Monda asked him whether he could get back his refund as he was traveling, and the said father of Dennis, that is Joseph Misati, said, yes, I can refund you, I have the funds, and actually gave him the amount. We will show from both M-Pesa accounts and from the bank accounts that indeed the money emanated and came from the accounts of Mr. and Mrs. Misati. Part of our defense team will address you on this, but I just want your attention to be drawn to this first point immediately in our response to the first count, that you will be subjected to the spectacle where a father is saying, this money belongs to me, I was refunding someone, a friend of mine of 32 years, money I had borrowed about 8 or 9 months earlier. You will be subjected to a spectacle where you have to choose whether to believe the father or to believe the son. You will be subjected to a situation where you have to determine whether the money actually belongs to the son or it belongs to the father and the mother. You will be subjected to a situation where you would have to determine whether the allegation of having sold a saloon has anything to do with this case, or it was fabricated with the intention of whipping up emotions. On the second count of the alleged giving of bribe, we do not deny that indeed an amount of 100,000 came from the M-Pesa account of the Deputy Governor to the account of Lucy Wahito. We do not deny that. However, we've explained, and we will show you the records, the M-Pesa records, showing that it was a mistake on the part of His Excellency Dr. Monda in the remittance of the amount, and that he had intended to actually remit the amount to somebody who had given him service, one Gladys Aminga, who had given him a transport service. We will show you that the phone records or the phone book recording by the Deputy Governor was such that the names of the two people were next to each other because they are both chief officers in the Kisii County Assembly, and that was just a mistake. Now, it is said that Lucy is eligible to be made a saint because he returned the money and refused to be influenced. We will invite your attention to two details on this issue. The first detail is that by 28th of May, interviews and scoring of the candidates had been done about 13 days earlier, that is on the 15th of May. So that by 28th, really, the person who had successfully contested for that office had been determined by reason of the scores done by the various members of the board. It had nothing, it could not possibly be a basis to have influenced who would be assigned this job. The second issue that we will be addressing on that issue is in the statement that was presented by Lucy at the County Assembly. She was very explicit. She said, I received an amount of 100,000. I called the Deputy Governor and asked him, what is this money for? She says that when I asked the Deputy Governor that question, he kept quiet. On our part, we are saying that the Deputy Governor told him, it is a mistake, I meant to send it to Gladys. But just leaving it, we are taking Lucy's statement at its best. Lucy does not say it was meant to influence the decision she was to make or the board was to make for purposes of giving the job. Now, after having appeared before the County Assembly and having presented our case, immediately the County Assembly, the people sponsoring this motion, went back and did another affidavit. And now Lucy suddenly remembers that indeed there was a very specific statement by His Excellency Dr. Monda saying this money is meant to assist me on unemployment. We just pray, honorable members, that please do give consideration to that change of mind, that this change of mind is caused by the way we conducted our defense at the County Assembly and is meant to fill up gaps. And probably to just emphasize that indeed it is a statement made after we had put in our defense and was meant to influence this Assembly, this Senate, to think that indeed her earlier statement saying he kept quiet is not necessarily accurate. The third thing I'll be requesting, we will be showing, and we requested that you take into account, is that it is said that Lucy received the money, asked for it to be reversed, and then eventually sent it back when it was not reversed. Now, I pray that you just keep in mind the dates. It is said that the money was received on 28th. Lucy returns the money on 30th, 2 days down the line. We will take you through the M-Pesa and show you that Lucy must have celebrated the receipt of this money. Because if you look at the M-Pesa account, you will see how she immediately utilized that money upon receipt of that money. And so we will be saying the hero they are referring to is not actually a hero. But on our part, our point of emphasis is simply to say this, that it was a mistake, the money was returned, and Dr. Monda was constrained and compelled to look for another money to pay the said Aminga who was meant to have been paid and whose name is next to Lucy. Now, coming to the issue of threats, just probably one more statement on that issue of Lucy. We will be requesting that in fairness to Dr. Monda, we do recall our lives and remember that from time to time we have made mistakes in sending money to the wrong person when we intended it to be to somebody else, and that mistake cannot be taken away from Dr. Monda merely because he's standing trial. On the issue of threats, Dennis Misati, the son of Joseph Misati, who will be coming to testify, says he was threatened and he relocated with his family. we will be showing that indeed there was no communication between Dr. Monda and the said Dennis Misati. The demand letter is saying he made, we are not aware of. The late report to EACC, which he says is the basis of that threat, there is no demonstration of that. It's just a mere allegation. And as a matter of rule of law, he has not made any report to anybody that indeed he was threatened to the police. And these allegations are made 8 months down the line. On the allegation of the misuse of staff, we will be demonstrating that indeed as a deputy governor he is entitled to be assigned some staff members to help at home. We will be demonstrating that the allegation that these staff members, and I'm surprised that my colleagues, it is not anywhere in the pleading, so I suspect it is my colleagues who have come up with it, saying that these staff were cooking for dogs. I wonder why they had to choose dogs. But our point would be this, that the deputy governor is entitled to staff members. None of those staff members have said anywhere that they have been misused. It is said that these staff members were used to dig a well. And this should be in the period of around 2024-2023. We will be showing that indeed there has been no well dug at the deputy governor's home in the last almost 10 years, because the well was dug in the year 2003. We will be showing that indeed he doesn't have dairy, and that bit of the allegation that he was using the staff to manage dairy is not true. We will be demonstrating that he doesn't run any farming in Kisii. The land assigned to him is used for purposes of, he has planted trees on the farm, and so he doesn't have any farm which he could deploy the staff to work in. And we will be saying this is a complete falsehood, unfortunately, from his brother. Now, on this point, I just want to hang on 1 minute and invite your attention to this. So, on the first two counts of, or rather the first count of taking a bribe, on the third count of threatening Dennis, you will be having a situation where the father is testifying against his son, or rather the father and the mother are testifying against his son. On this count of their late misuse of staff, and the next point being the arrest of the brother, you will be having a situation where this Senate is being asked to take the place of the mother of the two brothers and preside and determine their dispute. We are saying that this Senate is being reduced to an unfortunate level by being asked to preside over disputes over families, and a colleague of mine will address you on that. Lastly, on the issue of the arrest of the brothers, we draw your attention to the point that it is Dr. Monda's case that indeed he planted the trees. The trees belong to him. He planted way back in the year 2007. We've called witnesses who were involved in the planting of those trees. The brother came in and started cutting the trees. Dr. Monda did nothing other than to just report to the police and say, my brother is cutting the trees that belong to me. The police did the investigation and determined that indeed, from the face of what they had, it was the brother who was on the wrong in cutting the trees belonging to Dr. Monda and had him arrested. That will be our case. One of the things then you'll be being asked then is whether you want at this Senate level to make a choice of believing either the brother, that is Robin, or Dr. Monda Robert. The second one is whether you want to take up the role of the police who are already investigating the issue. Now, my colleagues have tried to make the issue a motive by saying that over 20 people went to arrest Dr. Monda. Now, again, our position is that he merely reported and the police went to arrest him. However, even assuming 20 people went to arrest, and we are saying we don't know how many people went to arrest, but even assuming 20 people went to arrest, is the issue the number of people who went to arrest, or whether there is a culpable offense, whether the police were entitled or at a legitimate reason to effect the arrest. So that the issue of the number of people, the issue of the summons for a guy is really relevant. It doesn't change anything. What matters is whether or not Dr. Monda was right to have reported and whether the police were acting within the scope of their duties in effecting the arrest. Then, Mr. Speaker, the County Assembly then on the 21st of February 2024, resolved that before they determine the impeachment of the deputy governor, they should go for public participation. They went for public participation, and one of the results of public participation was a memorandum written by one Benson. That Benson then brings a memorandum accusing Dr. Monda of some excesses. Mr. Speaker, sir, I request for your direction. Your assistant is threatening me with 15 minutes. My conscience, I am aware that my colleagues used over 1 hour. I would only pray for, because I'm here to address the issue of the preliminary, the issue of the expansion, expunging some documents. I just pray for equal timeline, Mr. Speaker, sir.
Council,
I promise to be
Council, that
responsible
is
on
not a
time.
threat. That wasn't a threat. Indeed, you have 15 minutes. If you're not done within those 15 minutes, then you can make your plea, and I will direct when we get there.
Thank you, Mr. Speaker, sir. I would request the honorable senators to look at the document filed by the deputy governor, and it is marked DG in blue. And if you look at page 56, Page 56 contains the only document we received from that public participation, being a memorandum written by one Benson Nyakaka Misario, saying that the deputy governor should be retired from his office for various reasons, which in general amount to abuse of office. That memorandum was part of the invite for public participation, because public participation said you can bring written representation or oral representation, and so the document then was delivered to the speaker, as you can see on the face of it at page 56, and to the clerk, as you can see at that same page 56. It is then copied and delivered to the governor, and in consequence, therefore, when the governor went to the county assembly, he defended himself on the 5 counts that I have just gone through, plus the issues of the abuse of office. And so, when my colleagues say you should expand the contents of paragraph 48 to 49, my colleague Ndegwa said that 48 to 49, and the reason is because it is a new material that was not part of the charge, then it poses the question, what was the intention of the public participation, and what were we to do with it? Because the earliest we had notice of is when it was served on us, and we knew that is an issue we had to respond to, and therefore we did a response to it. Mr. Speaker, sir, I would like then, and then therefore we have responded to it from that paragraph 48 to the last paragraph. Now, Mr. Speaker, sir, that then creates the link between our factual response to and we have factually responded to all the things that Mr. Nyakaka has raised. Amongst, and our main defense is that these are not issues we are responsible for. It is more of in the hands of the chief executive, the governor himself. The question of a budget that had been passed by the assembly having been manipulated and changed after the assembly had passed. The issue of the Kisii County budget not having been utilized for the last over 18 months. The issue of the deputy governor's wife being the one who is actually in charge of the county. All those issues are accusations against the governor, and we had to respond to them. Now, Mr. Speaker, sir, and honorable members of the Senate, when you go back to reflect on whether you will expand these paragraphs from paragraph 48, we request that you keep a clear mind about the dichotomy of this issue. If the reason for wanting to expand is that it was not part of the case at the county assembly, then that is wrong on the face of it, because it was part of the case. They went for public participation, we were served with this document, and so we had to come and respond to it. However, if their argument is that it is not part of the 5 grounds that Honorable Siocha moved when he was seeking impeachment, before then he asked for public participation, then that's a different issue. But we pray that you please do not expand them merely because, or rather on the ground that it was not part of the case at the county assembly. It indeed was part of the case at the county assembly, and you will see it on the face of the documents. Now, you've then been asked to remove those documents because they are not relevant. I would like to submit to you, Honorable Senators and Mr. Speaker, sir, that the question of whether those are relevant or not belongs to you. It doesn't belong to the judgment of the assembly. It's not the assembly who says, we went for public participation. We enjoy the parts where they say, remove the deputy governor because he disrespects the wife of the governor, because he has taken a bribe. We don't want this, we want this. It is not for them to choose what should eventually come to you. It is for you to determine whether or not they are relevant. And so I insist that you retain that paragraph 48 to the last and determine at the end of your whole process whether they are relevant or not. And nobody should take away your if I were in court, I would say your jurisdiction to determine the relevance of that and to apply it in the question of whether or not you agree with the motion for impeachment. Now, my colleague was very specific. He says that, for instance, at paragraph 61, there is reference to the wife and to the governor, and that those people are not here to defend themselves. And we are saying that's not the correct position. We are not here to discuss, we are not here to determine the status, the fate, and the situation of the governor and his wife. We are here merely to defend ourselves. We received a notice from Benson telling us for these grounds, the governor should additionally be impeached. And we just come here to say, no, you shouldn't impeach us for that reason, because these are our reasons. And if it were to be then the case that in our defense we are saying that it is not the deputy governor who is responsible for the changes in the budget, for non-use of the budget, and so on and so forth. If that is the case, that it is the governor, that's our defense. It is not intended to bring into issue the governor and his wife. It is only merely meant to persuade you that indeed that's not a ground upon which you should impeach the governor. We would therefore be asking you to determine the question of the place of the public participation in these proceedings, because that is actually a product of the public participation. And I would probably just want to mention one thing to you, that at page 41, in the public participation, if you look at page 41 of the, if you look at volume 1 of the Assembly's bundle, page 41, they have brought to you the product of the public participation, as they say. And this, what was said at Birongo Ward is something that appears in quite a number of other places where public participation occurred. Bullet number 2, it says this: the members also lamented that the deputy governor does not respect the county first lady, and therefore the MCA should be allowed to perform their duty of impeaching him. So that public participation that was initiated by county assembly in itself, in many places said, unless the deputy governor is prepared to go and kneel before the first lady, he should be impeached. And we are saying we are not under an obligation to have to kowtow to the wife of the governor. Now there is, I would like also to invite you to page at page 36. There is another output of the public participation. This is, my apologies, volume 1, the governor's, the Assembly's bundle, volume 1, page 36. There are input from a place called Masimba Ward. In that Masimba Ward, it is said no members of public were at the venue when the secretariat arrived. And so there was no product of the public participation. However, and this will be our case, that there has been a continuous generation, fabrication of documents and material to incriminate the deputy governor. If you look at the letter from there's a letter dated 8th of March. I'm afraid probably the honorable members may not have this, but this is a letter dated 8th of March written to Honorable Robert Onsare Monda, telling him, come and defend yourself. It is written by one of your staff members, one Tekaya Ogoso. And he says, some of the people who you will need to come and respond to at page 3 is a gentleman by the name Muse Shamba from Masimba Ward. So you have public participation report from the county saying nothing happened here. But you suddenly have somebody who has been set up to come and say, this is what Masimba Ward is saying. And we are saying this is part of the long and false fabrication of material to incriminate the deputy governor. For those reasons, Honorable Senate and Mr. Speaker, sir, we pray that you do not expunge that paragraph 48 to the end, and that probably at this point I should just move on to the preliminary objection and then call it a day. Now, Mr. Speaker, sir, unlike my colleagues, Mr. Speaker, sir, I pray for just a few more minutes. Could I request for about 20 minutes, please? Kindly.
No, I'll give you a further 15 minutes. 15.
Thank you, Mr. Speaker, sir. Did you say 50? Now, Mr. Speaker, sir, unlike my colleagues, you will see at page, the Deputy Governor's bundle, we have at page C, this ABCD, the first part of it, we have come out very clearly and said we will be raising a preliminary objection. And I would like to prosecute that preliminary objection and collaterally respond to the preliminary issue raised by my colleagues. In that preliminary objections, Mr. Speaker, sir, I have made reference to your I've made reference to the third schedule being your rules of procedure on impeachment, and those rules state to the effect that I have particular reference to Rule 14, Rule 20, and Rule 30. Rule 14 says any preliminary question or issue raised by the County Assembly or by the Governor shall be argued, and so on. And then at Rule 20, which is where I really want to place a lot of investment on, Rule 20. Rule 20 states, in presenting its evidence, the Assembly shall not introduce any new evidence that was not part of the allegations against the Governor by the County Assembly as forwarded by the Speaker of the County Assembly to the Speaker of the Senate. Now, honorable members, that section creates three thresholds. The first one is that it targets the County Assembly. It doesn't target the subject of the impeachment. It doesn't say Governor or Deputy Governor cannot introduce new evidence. It says the Assembly shall not introduce new evidence. I pray, Mr. Speaker, sir, that the evidence, the new evidence introduced to this Assembly by the county after the close of the proceedings of the 29 be expunged from the record, and we limit our case to what was presented to the Assembly. So the first issue is that it is a prohibition on the Assembly. Number two is that it prohibits new evidence. Number three, it's that it prohibits new allegations. And number four is that the limit is what the conversation between the Speaker of the County Assembly and the Senate Speaker. Now, for purposes of determining that preliminary objection, we would be making reference to the letter dated 1st March 2023, being the letter written by the Speaker of the County Assembly to the Speaker of the Senate. And in that letter, at at page 7 to page 8, they have listed the items that the Honorable Speaker read at the start of these proceedings, being the notice of motion, votes and proceedings, the order paper, and so on and so forth. However, when the letter was being written to the Deputy Governor, asking him to defend himself by a letter dated 8th of March, the contents of what the Speaker of Kisii County Assembly had forwarded to the Senate was changed completely. We have a new case completely. In the new document page, it has 3 pages. They have introduced the other one has about 20 documents. Even document number 20 is excluded. This new one has 24 documents. And if we are being faithful to the wording of that Rule 20, that there should be no new allegations, there should be no new evidence, and it should be limited to what the speakers communicated between themselves, then this letter written by your staff member, Directorate of Legal Services, is a scenario where your staff is now changing the case that the Speaker of the Senate is aware of to another case altogether different. He now tells us we need to respond to issues of a video, a flash disk brought from Jen Bonareri, Mushe Samba, James Orenge, David Obiri, Che Mombasa, Fred Anyona. It asks us to also to respond to a report of public participation, which we have never seen. We are seeing it for the first time. We are looking at those flash disks for the first time as we come before you. It asks us to respond to contentions from David Akai. It asks us to respond to Gladys Aminga. And we are saying all these things were not part of what was in the county assembly and what we responded to. And so, Mr. Speaker, sir, members of the assembly, we will be praying that you make a determination of the very substantive issues to this effect. Number one, whether a case that was determined at the county assembly can mutate so that by the time it is reaching here, it is a different case from what was at the county assembly, or you receive it as an escalation and limited to what was done at the county assembly. And whether you have original jurisdiction then to entertain a question of impeachment. Because in the flash, it is alleged that the deputy governor received some money, 20,000 from this person, 5,000 from this person, and that's not a case we have had an opportunity to respond to. The gentleman by the name Akai, who against whom the summons are being asked, is being asked to produce the summon, says, I was told by the ward administrator that this happens. Hearsay, first of all. But the second thing is, it is not an issue that we had an opportunity to respond to. And for those reasons, then, we pray that the new evidence introduced be expunged, and we have particular reference to the contents of paragraph 14, paragraph 22, paragraph 23, paragraph 24, and paragraph 25 of the letter from your Directorate of Legal Affairs, which changes the case from what the Speaker said. Now, in that same letter, it is the Directorate of Legal Affairs also says that please also find a letter from Mr. Ndegwa, which now brings new case. And we are saying, what is the wording of that Rule 20? It says what the Speaker communicated to the other one. When did Ndegwa become...
Council, that letter you're referring to?
Yes, ma'am. Yes. Sorry. Actually, that one I can show
contained in our volume.
Yes, may I show you who?
Kindly direct the honorable senators to the volume and to the page.
Yes, it is the County Assembly's bundle, volume 1, page 336, please. 336. Yes, 335. It's the last page actually. It's practically the last page on the bundle, this bundle here, volume 1. And honorable members, even as you look at that letter, please allow me, I know you might not have this letter which was written to Dr. Monda telling him to come and defend himself, but allow me to just read the first paragraph. It says this: the Speaker of the Senate on 2nd of March 2024 received communication dated 1st March 2024 together with a bundle of documents, stock records, from the Speaker of the County Assembly of Kisii for removal from office of the Deputy Governor of Kisii, Dr. Monda, for impeachment. And then it is listed. Now, when you go to the second page of that document, then it says, sorry, it is in the first page. Item number 1, it says, a letter dated 1st of April. No, sorry, this one you do not, I'm just referring to the letter that was written to the Deputy Governor telling him to defend himself. And I'm saying in that letter, the writer of that letter from your Department of Legal Affairs introduces things that the Speaker of Kisii had not said anywhere. And amongst them is the letter from Degwa. And in that letter of Degwa now, we are meeting it in this assembly for the first time. They are saying a fair copy of an affidavit from Dennis. That we never saw. I'm looking at page 335 now.
Yes, what is the issue, Senator Kavindu?
I thought what is taking us through, we should be having copies so that we can follow with you. Because it's taking us through the process so that we can give a ruling. We should have the documents that is taking us through, Mr. Speaker.
Very well, Honorable Senator. Council, again, kindly, as you make your opening statement, if you're referring to a document.
Honorable members, I'm referring to page
to the volume and to the page.
Yes, it is volume 1 of the Assembly's document. It is practically the last page. However, unfortunately, I have to cross-reference it to the letter that was written to Dr. Monda telling him to come and defend himself.
So that letter
is dated
to Dr.
8th of
Monda
March.
is contained in a different volume? Oh, it's not within the bundle of documents?
It is not in any of the bundles, Mr. Speaker, sir.
So can it be circulated, Clerk? That's a document from the Senate, so can copies be done and
yes,
circulate? Yes, according to Council, it emanated from the Council.
Yes, it emanated from the Senate.
It emanated from the Senate.
And it is a letter directly responding to the letter from the County Assembly forwarding the material that was used to impeach the Deputy Governor. And honorable members, all I'm saying is, under the Rule 20, it says this: the case of the County Assembly shall not change in terms of evidence and shall not change in terms of allegations, and will be limited to what the County Assembly Speaker communicated to the Speaker of the Senate. That is the scope of the law. That's Rule 20. Now, in this letter then from the Senate, which is a response notifying us to come and defend ourselves, it immediately changes what the Speaker from the County Assembly had done and introduces new evidence, which begs the question, who intervened and introduced new evidence? And one of them is the letter from Degwa dated, which is the one I'm talking about at page 335. In that, this is what we are being asked. A fair copy of the affidavit of Dennis Misait. I'm looking at paragraph 3, honorable members. It says, a fair copy of the affidavit of Dennis Misiati, a flash disk containing video clips emanating from public participation, including the one I told you about, Masimba. 3, an affidavit of Orenga Yenda saying I was manipulated on a land sale agreement, and 2 crucial protected witnesses. And Mr. Speaker, sir, the preliminary objection we are saying is expunge everything that was not communicated to you by the Speaker of the County Assembly as prescribed by Rule 20. Let the case be limited to the 5 counts plus what Benson says, and exclude everything else that was not part of it, which is what I've just referred to, being those paragraph 14, 22, 23, 24, and 25 of the letter from your Directorate of Legal Affairs. I would just want to close by saying this, that if you constrained us to respond to some of these new things, including Agai, the flash disk and all this, you will be taking away our constitutional rights under Article 47 and Article 50 for fair hearing. We are entitled to at least 3 days notice at the assembly of the case we are supposed to face. We are seeing these things for the first time as we appear before you for purposes of defending ourselves. Mr. Speaker, sir, I want to beg you to please just allow me another 10 minutes my colleagues to just say something very briefly in support of my preliminary objection and opening address. Very kindly, Mr. Speaker, sir.
5 minutes. 5.
Okay.
5.
I will ask Mr. Ochoki first, and then my colleague, and I hope my friend Honorable Gerard Ket won't mind.
Honorable Speaker, honorable members of the Senate, for record, my name is Wilkins Ochoki, part of the team representing the Deputy Governor Kisii. Honorable Speaker, what is before this Honorable House is not a motion that meets the threshold that will send the DG home. Allow me very respectfully refer to this as nothing more like what we see in the Chinese martial arts movies. It's all fiction, Honorable Speaker. And my senior, Katwa Kigen, has referred you to the Standing Order 88 of this Honorable House, which pursuant to that is referred, pursuant to Standing Order 88, Honorable Speaker, Rule 20 of the Rules of Procedure for Hearing and Determination of the Removal of either Governor or Deputy Governor was created, and that rule, as my seniors very well addressed you on, does not allow the County Assembly to bring in new evidence. Because of time limit, Honorable Speaker, allow me just say that what the County Assembly is doing is nothing more than a fishing expedition. The Hansard is clear that upon the Speaker of the County Assembly being asked whether the public participation documents are going to be used in the proceedings of the County Assembly, he was clear that there was nothing at all that was being used. Now you are being told that there are video clips that have been brought, witness statements that were not there. So, Honorable Speaker, I'll respectively just submit that the same ought to be disregarded. There was an application by my learned brothers that you expunge part of the affidavit of the Honorable Deputy Governor. Honorable Speaker, you'll notice that from precedent, this House has allowed governors and deputy governors that did not defend themselves in the county assemblies come here and defend themselves. In any case, the House needs to know the genesis of the problems in Kisii. What exactly is on trial? Because it's not common that the honorable members of the county assembly can wake one morning and determine that a deputy governor that was elected should just go home. So what we want to bring out, Honorable Speaker, is the genesis of the problem. And very briefly, Honorable Speaker, allow me just address preliminary point 2, because my senior Mr. Kigen has addressed one within a minute. Honorable Speaker, you'll notice, and the Honorable Deputy Governor agrees that Article 181 of the Constitution, Section 33 of the County Government Act, and Standing Order 60 to 64 of the Kisii County Assembly Standing Orders allow for the impeachment of a governor and a deputy governor. But there are clear timelines that are provided. You will notice, Honorable Speaker, that in the County Assembly of Kisii, and I'll refer the Honorable House to page 5 of the document titled DG. You will notice, Honorable Speaker, that at page 5 of that document of the bundle titled DG, there is a document titled Notice of Motion that is dated the 13th of February 2024. That document was the motion that was brought to the House by the Honorable Wycliffe Siocha. Somehow it mutated, and by the time it was being brought again to the House on 21st of February, we now had another document which starts at page 6 of that document titled DG, so that you'll get, Honorable Speaker, that the Deputy Governor was defending himself on two documents dated two different dates, and even then, based on the document in page 5 of the document
that was received in the County Assembly on 13th of February, Honorable Speaker, the Standing Order 60 to 64 provides that that motion ought to have been heard within 10 days. Whereas we do not want to bring up substantial or procedural issues in this house, but you will consider and look at the timelines within which the County Assembly sat, and you will notice that they sat or determined that motion beyond the 10 days that is provided for in the Senate. And as we will explain, and you will notice that this is beyond the character of the DG. This is all politics. It's all about the hard questions, the tough questions that the DG is asking, that we promise to deliver to the people of Kisii County. We are not delivering. And upon asking those very simple questions, he is now being brought to you and you are being told, send him home. Thank you very much, Honorable Speaker. Allow us very, very kindly, because I believe it didn't take a lot of time, just bring Honorable Osoro, who's our colleague, to take 2 minutes only, just to finish up and give a final brief on our opening remarks, kindly.
Senator Chirange, what is your intervention?
Mr. Speaker, so that we dispense of this matter and also for posterity, because traditions and precedent are important, I raise under Article 75 on the conduct of state officers, Mr. Speaker, and I beg to read, and I shall be very quick. A state officer shall behave, whether in public, an official in private life, or in association with other persons, in a manner that avoids any conflict between personal interests and public or official duties, compromising any public or official interest in favor of a personal interest. So, Speaker, I invite you also to look at our standing orders, just in quick succession of Standing Order number 252 on attendance before the National Assembly and reverse. So, Speaker, Mheshimiwa Silvanus Osoro is a member of Parliament of South Mugirango, where the Deputy Governor is facing impeachment allegations. Number 2 is the Majority Chief Whip in the National Assembly, Mr. Speaker. So my concern, in as much as I'm aware of Article 50, but you must interpret the Constitution, both Article 50 and Article 73, Mr. Speaker. I'm aware Deputy Governor Monda is allowed to have a legal representative of his own choice. Mr. Speaker, is it in order for my brother Mheshimiwa Silvanus Osoro, the MP of South Mugirango, to appear on behalf of Robert Monda, the Deputy Governor? 1, because he's a state officer, and 2, of conflict of interest, that he might send a mixed signals that he is a chief whip of the majority side in the National Assembly. And number 3, whether, looking at Standing Order 252, whether the procedure of ensuring him appears before the Senate, not only as an advocate, but also as a member of Parliament. Mr. McHugh, under Article 93, member of Parliament is both a senator and a member of National Assembly. Mr. Speaker, some of us who are learned friends would have wished to appear on behalf of either side. If we allow Honorable Osoro to appear, it means as a member of Parliament, as defined under Article 93 of the Constitution, we can also appear on behalf of either sides that are bringing impeachment motions, Mr. Speaker. And number 2, and finally, it is in the public domain, and this will be my conclusion, that the governor of Kisii, Mheshimiwa Simba Arati, and Honorable Silvanus Osoro have had a public altercation. Mr. Speaker, I beg that we should not use Senate as a playground of local politics of what is happening in Kisii, Mr. Speaker. Could it be Senator Osoro, Honorable Osoro, and Simba Governor Arati extending their playful political ground to the Republic of Senate, Mr. Speaker, where we are here only to listen to charges that have the basis of evidence and can stand the test of legal and constitutional and standing orders, Mr. Speaker. So I beg that you rule that Honorable Osoro should relinquish himself from representing Honorable Monda, go back to his house business in the National Assembly, and serve our party, the UDA and Kenya Kwanza majority national. He is a chief whip. We might lose some of the bills at the National Assembly, while Mheshimiwa Osoro is busy representing for personal, financial, gainful, and propelling his professional at the expense of the position that we gave him in the National Assembly, Mr. Speaker. So I beg your ruling, and Senator Osoro should go back to serve the people of South Migrango and members of National Assembly, Mr. Speaker, and allow this House to proceed. And I know Senior Counsel Katwa Kigen and the other retinue of colleague Leonard can do their job well, Mr. Speaker. So I request that on PO, let Mheshimiwa Osoro. There is no problem. They can still continue fighting with Governor Arati in funerals in Kisii, but not in this House. I submit, Mr. Speaker, sir.
Now, yes, Senator Boni. I hope it's a new matter altogether, not related to what has already been raised.
Mr. Speaker.
Is it something new, Senator Boni?
Yes.
Proceed.
It is new to the extent that he has raised 4 things upon which you should rule. Mr. Speaker, I'm inviting you again to consider ruling on a 5th thing, namely that whereas this is the Senate, but in this chamber this morning and for the next 2 days, Mr. Speaker, we have converted ourselves into a trial chamber. And therefore, Mr. Speaker, any member of Parliament seated in this chamber is seated here as a judge to what's going on. Mr. Speaker, the invitation I'm asking you to make is that if you allow the Honorable Osoro to then sit in this House and do something other than what a member of Parliament is supposed to do in a trial chamber, is it not, Mr. Speaker, tantamount to having a sitting of the High Court, for example, where a judge who would have sat on that matter then jumps and becomes an advocate in the same court, Mr. Speaker? And Mr. Speaker, because we are now going to be setting a precedent, we request you to consider this issue long and hard, because we have some very eminent lawyers in the National Assembly and this Parliament who will then start abusing this to the extent that it will be the disadvantage to the impeachment process. I thank you.
Senator Sifuna.
Thank you, Honorable Senator. First of all, I join...
Is it on the issue of...
no, it's a separate issue.
It's on the issue of Honorable Osoro?
I want to go on record, Mr. Speaker, as supporting to the positions taken by the 2 senators. But I wanted to, with your very great indulgence, Mr. Speaker, because one of the parties has asked us to make a decision on a matter, I was hoping, Mr. Speaker, I could find some clarification on the understanding of the rules of the procedure for this particular process. Mr. Speaker, allow me to find out from the advocate for the deputy governor whether in their understanding there is a distinction between evidence and an allegation. Because my understanding of the standing orders, at least as I have read them, is that for as long as there is evidence supporting an allegation that was present in the county assembly, and I'll give a very specific example. If you're being accused of, say, corruption, is it possible that if there are 10 pieces of evidence and 7 are used in the county assembly, is it possible, or is it their position, that the remaining 3 pieces of evidence supporting the same allegation that was present in the county assembly cannot be presented before the Senate? That is the question I want them to answer for me as I ponder what to do with their objection. And number 2, whether it is their understanding that a public participation is a evidence collection forum. Because in my view, Mr. Speaker, when you go for public participation, you are presenting the case against the deputy governor as framed in the county assembly for the public to engage with that case. So that if I'm being accused of corruption, and that is what goes to public participation, is it possible that other people, upon hearing those allegations, might also say, I was also a victim? And then what in their understanding are we supposed to do with that material? I thank you, Mr. Speaker.
Council.
Thank you, Mr. Speaker, sir, and honorable members. Our emphasis on the Rule 20 is that it prohibits both new evidence and new allegation. Now, on the face of that rule, it's not very clear indeed, and that is an issue I've belabored, whether the intention is that evidence that supports an already existing count is tenable. However, the words used are assembly is prohibited from introducing new evidence that was not part of the allegations. So that if there is an allegation already in place and evidence was already adduced to support that allegation, you cannot bring new evidence in addition to what was canvassed at the assembly. That's my understanding. I can see you disagree with me, Honorable Sifuna, but that is my understanding of it. That it is cast in stone what was done at the assembly to the extent of the material in support of those counts is what should be brought here. Because then the inverse argument, Honorable members.
Councillor, I think you've made your point.
Yes, and then there's a second limb of what he was asking, what becomes of public participation. Public participation in itself is a wild animal. You wouldn't know what will come from public participation. But it is my position that if in the public participation somebody were to say that indeed I have been a victim of corruption from the same person who is facing an impeachment, that is a standalone case that should go back to the assembly. It cannot be a basis of a case before the Senate, because then you will be placing the subject of the impeachment in a situation where he has no chance of responding to the new allegation brought in through the public participation. So if the evidence, for instance, collected from the public participation were to say I was present when the M-Pesa was being sent to Lucy Wahito, or I was present when Dennis was paying the bribe, then that in a way probably you could almost accommodate. But when he says I also was asked for a bribe, then that's a new case. We should go through the whole process of impeachment, right from the point of the motion to the point of, from the point of notice to point of motion, and so on and so forth. That is my answer, Honorable Speaker.
Senator Roba.
Thank you, Mr. Speaker. I just want to bring to the attention of the House on the issue of expunging certain submissions. Mr. Speaker, I think it is imperative that we understand that the individual who's on trial here is the Deputy Governor, Mr. Speaker. And when I look at some of the submissions and where we are being pulled towards in terms of for instance, the reference on page 56, where we are told that we have to listen to certain issues that have been submitted with regards to the governor's wife, Mr. Speaker. As you have seen, and we have all seen previously, we have really tried as a Senate to stay away from the issue of the office of the First Lady or the First Gentleman, Mr. Speaker. And more often than not, including in these submissions that I have had being discussed in terms of being expunged, more often than not, it is a way of digressing this House from actually focusing on the charges, Mr. Speaker. The charges that are before us are 4. They are of gross violation, abuse of office, gross misconduct, and crimes under the national law. None of these charges, Mr. Speaker, are directing us to the wife of the governor. Mr. Speaker, so as you make that ruling, I implore you, Mr. Speaker, that you understand that this issue of the office of the First Lady and the First Gentleman is often being used to bring non-issues to this House, Mr. Speaker. So I want to point out to both parties that, first of all, the governor's wife is not going to appear before us. So therefore, we should, it is not forming part of this impeachment. And so therefore, Mr. Speaker, if you can guide that we do not reduce the House into a House that is going to discuss matters of patriarchy or feminism, or the issue of the first office or not the first office. The person who is here is the deputy governor, and we should limit our discussions on whether this particular impeachment has weight to impeach a deputy governor, and leave away the issues of or trying to bring about the spouse of the governor or any other person in this impeachment. Thank you, Mr. Speaker.
Senator Ledama.
Thank you, Mr. Speaker. Mr. Speaker, I want to bring to your attention Rule 30.
You have less than 2 minutes.
Okay.
And Rule 23.
Okay. Rule 20. Okay. Thank you, Mr. Speaker. Mr. Speaker, I was trying to make sense of what the two parties, the Assembly and also the Deputy Governor, were trying to allege in terms of the introductions of new evidence. Mr. Speaker, Rule 30 of our impeachment rules states as follows: that when a particular question or matter, including but not limited to questions of evidence, materiality, relevant competence, or admissibility of evidence, and any question consequential or incident thereon, no provision has been made in the standing order or in these rules, the Speaker of the Senate shall rule on the questions on matters, and the ruling of the Speaker shall be final. Mr. Speaker, the reason why I stood up is because of the parity of the evidence. In this case, I've had both parties alleging that there is introduction of new evidence. I'd like to request that you apply Rule 30 so that during our closed session, you can determine that matter, and then we can be able to progress. Thank you, Mr. Speaker.
Now, to make progress, I'd wish to hear from the Deputy Governor's team a response to the preliminary objection by the Senator for Nandi. And also I'd wish to hear a response from the County Assembly on the preliminary objection by the Senator for Nandi. Proceed. Proceed. I'll come to you. Okay. Honorable Senators, I'm informed that the Senator for Kisii cannot hear me because you're making noise. Kindly be silent. Proceed.
Mr. Speaker, sir, my understanding is that you're inviting me to respond to Honorable Ladema's point in reference to Rule 30. Oh, okay.
For Nandi, who raised the preliminary objection opposing the appearance of Honorable Osoro.
Mr. Speaker, sir, I'll be as brief as this. Our position is that this Honorable Senate and the National Assembly are different functions. Number two, the impeachment jurisdiction that you are exercising today is not a function that is exercised at National Assembly. And for that reason, there is no conflict in Honorable Osoro appearing here, considering that there would be no occasion and no situation where we would have to influence or contribute to the question of whether the impeachment can proceed or not. I would also want to identify myself with the submissions by Honorable Kalwale and say, up to the last minute we were together in the sense that if you are sitting already as judges, then we know that your members have appeared before court and conducted proceedings there. And insofar as therefore you're sitting as a court, then Honorable Osoro, for as long as he's not a member of this Senate, can participate the same way your other members have been able to make contribution in the court precincts. I pray that you allow Dr. Monda to enjoy the services of an advocate of his choice. Thank you, Mr. Speaker, sir.
Mr. Speaker, sir, part of the benefit of attending law school and being a senator as distinguished as they are is that allow me to address the senator for Nandi as my junior learned friend, that he has correctly put it right, that there is no distinction, constitutionally there is no distinction between the National Assembly and the Senate. Pursuant to Article 93, there is established a Parliament of Kenya which shall consist of the National Assembly and the Senate. And as such, my learned friend Mr. Osoro, with all due respect, cannot then behave like a ping pong. He cannot have his bread and eat it. He must choose whether he wants to be a legislator or he wants to be an advocate. The tragedy of premising a case such as this one on misconception of facts is that Mr. Osoro wants to convert this distinguished assembly to a field day somewhere in Nyarimbari Church. And as such, Mr. Osoro then cannot then continue to appear as an advocate and as a member of parliament. He has to choose which court does he want to wear.
Now, honorable senators, it is now 1:38. We are going to adjourn and resume at 2:30. I'll be delivering my ruling at 2:30 before we proceed with evidence by the County Assembly. Now, the issues that have been raised that require my determination are: one, whether we should allow to summon Hagai, a request, an application that has been made by the County Assembly. Two, whether to expunge certain paragraphs for being irrelevant as submitted by the County Assembly. Whether to expunge certain paragraphs and documents for, one, introducing new evidence and material as submitted by the Deputy Governor, and secondly, whether the documents as submitted by the County Assembly of Kisii did violate a mandatory rule that required the County Assembly to deliberate on this matter within 10 days. It is the submission of the Deputy Governor that the County Assembly of Kisii violated that rule by sitting outside the 10 days. That's a matter that I will rule on. And lastly, whether Honorable Osoro can appear for and on behalf of the Deputy Governor. So those are the issues that we will rule before we proceed to take evidence from the County Assembly. So, yes, Council?
Mr. Speaker, sir, I'm just seeking for your guidance, and I can read the mood of the House, is whether on that particular issue of 10 days, whether we could be given an opportunity to respond to the same because of an allegation as against our client.
Well, I gave you that opportunity to respond, and you chose not to.
You invited me to respond to the question of Mr. Osoro. But I leave it to the Senate, I believe.
Yeah, just leave it to us. The Senate is wise enough. Yes, Senator Sifuna.
Speaker, I wanted further clarification because we are all seated here as judges, and I hold the position that these are decisions that are to be taken by the House. At what point do we input as the judges before you render your decision, because I am hoping that it is not the decision of the Speaker, it is going to be the decision of the House.
I think, Honorable Sifuna, kindly arm yourself with the standing orders. All right, pick one of them. Pick one of them and read Rule 30.
Mr. Speaker, I'm very well versed with Rule 30.
Just read Rule 30.
I am well versed with the rule. I just want to say.
I am not versed. Read it.
But you cannot direct me to read.
Where a particular question or matter, including but not limited to questions of evidence, materiality, relevance, competence, or admissibility of evidence, and any questions consequential or incidental thereto, no provision has been made in the standing orders or in these rules. The Speaker of the Senate shall rule on the question or matter, and the ruling of the Speaker shall be final. I have not given you the floor, Senator Sifuna. I have not given you the floor. So, honorable senators, please be upstanding. Honorable senators, the Senate is adjourned until today, Wednesday, 13th of